Justice
Yes.
Supratim
The written notes of arguments filed today be kept on record. Full stop. Since oral arguments were concluded before a different bench, comma, the matter may be construed to be marked CAV by the said bench.
Obligement. ওই বেঞ্চটা কাল আছে আমি ফোন করেছি
Written notes. Alimony.
Yes, my lord, I am just now told, my lord, my learned advocate on record, my lord, contacted, my lord, tried to impress upon him, but my client says that, my lord, there is, my lord, a matter pending before the Honorable Supreme Court, where, my lord, SLP has been admitted. So, my lord, they are of the view that, my lord, possibly, my lord,
SLP has been admitted against what?
my lord, the order, my lord, fixing, my lord, the monthly maintenance.
Before the trial court in this case?
By your lordships, my lord, 3,60,000, my lord, was assessed. We have been making payment of that.
But there is no stay. There is no stay granted by the Honorable Supreme Court.
What is the number of the SLP? What is the date?
Number. My lord, may I,
We'll record that.
take it and, my lord, hand it over to my lord's, my lord, court of.
No, we want to know that.
Number.
At least the date you must tell us. Next date.
Order. Next date.
But I have a copy of the order. But this was the last order where it was sent for a mediation, but that also failed now.
I'm told 6 times, my lord, mediation has failed.
6 times when the mediation has failed, my lord can proceed with the divorce proceeding. There is no stay with the divorce.
So there is a contempt also?
But the contempt was with regard to they were not paying the amount of alimony pendant that now is pending, but they have been paying till now. This month they have not paid the entire amount. They have only paid 60,000. 3 lakh is yet to be paid for this month. Otherwise, they have paid after the.
You are fixing the appeal for hearing then.
I'll fix the appeal for hearing.
Well,
Lord, so far as the contempt is concerned, would it be my lord's kind pleasure, my lord, to dispose it of otherwise?
No, you have not. You have partially paid this month also. They say.
This month partially.
You keep it pending. The learned counsel appearing for the respondent, comma, on instruction, comma, submits that the respondent is not agreeable to consent to any quantum of permanent alimony. Push up accordingly. Let the appeal be listed under the heading specially fixed matters on August 20, 2026.
Okay.
Keep this with you.
Lord, in case, my lord, I can impress upon him. My lord,
Why should you impress upon him?
I
He's
have
not agreeable.
spoken with him. My lord, I will try and, my lord, impress
No,
upon
you cannot bring a horse to drink water.
Lordship, item number 4, Lordship, I'm
prepared and it was up.
Lordship, I'm led by Mr. Divanik Banerjee. He's on his legs, Lordship. I'm praying for short passover.
Don't grant any time.
Lordship, short passover because
no passover.
This with
No, sir, no passover. Either you start the matter or you dismiss for default. Specially fixed matters, we don't grant time. This is the first specially fixed matters. We are very sorry. Start the matter
because
in spite of repeated requests, comma, learned counsel for the appellant seeks an adjournment. Full stop accordingly. FA 130 can 130. FA 130 of 2026 is dismissed for default along with can 1 of 2026.
Lordship, may I start?
You don't have so much time. Sorry. Call on the next matter. We gave you 3 chances.
File the paper books.
Well, paper books filed today be kept on. Next. Call control.
Item number 5, Your Lordship, I'm for the appellant. This is, Your Lordship, that matter where, Your Lordship, the interim order, Your Lordship, was refused on the ground that there is an arbitration clause. Thereafter, Your Lordship, appeal was preferred. 2 reliefs, Your Lordship, actually we sought before the Honorable Trial Court. One, Your Lordship, regarding the access, that e-gate, my gate, Your Lordship, that access, Your Lordship, pass, which Your Lordship granted us on 6th of April 2026. Now, the second relief which we are seeking, Your Lordship, that Your Lordship, the gas connection from a common gas bank. That has been refused only on that basis, Your Lordship, that our construction of the property, Your Lordship, is allegedly unauthorized. This is, Your Lordship, the contention of the other side. Now, they also made, Your Lordship, a complaint before, Your Lordship, the Kolkata Municipal Corporation. the Kolkata Municipal Corporation, your lordship, did not find that any, your lordship, unauthorized construction in our premises, and your lordship, there are certain, your lordship, minor deviations.
Impediment you are facing to take independent gas connection.
No, actually, your lordship, in that particular society, there is a common gas bank and there is a gas chamber from where, your lordship, each and every flat they used to
Chamber
get.
sounds very ominous.
Your lordship,
Yes.
lordship, actually, what
It
happens
cannot be
in,
called anything else. Yes, you
in
understand.
society, your lordship, that is called gas bank, that is installed, your lordship, in a common
You want
space.
access from that. That
Yes.
is being given to everybody.
Yes, your lordship.
On what ground are they refusing according to you?
They are refusing
Yes.
that they are alleging, your lordship, that my particular premises has been constructed on a common passage, and that is not permissible as per the Kolkata Municipal Corporation Act, and that's why they are treating that particular premises as an unauthorized construction. My humble submission is they made a complaint before the Kolkata Municipal Corporation. The Kolkata Municipal Corporation did not find it as an unauthorized construction, rather some minor deviations.
Yes.
Now, after getting that minor deviation, your lordship, it was regularized. And they preferred an appeal before the building tribunal, and your lordship, even the appeal has not been yet admitted. Now, my humble submission is that they are nobody, your lordship, to decide that whether
What
they, in the sense, your lordship, the
owners association.
association. Because the reason is, your lordship, when the developer actually sold out that particular premises to me, I purchased that particular property for a considerable price, your lordship, around 9
You are
crore.
valid purchaser one.
Yes,
You are residing there.
I'm residing
It's an
there,
essential amenity. These are
and
your
this is an
primary-
essential amenity
And that unauthorized construction, one order is in your favor.
in my favor. And they could not get any interim order regarding the stay of that.
This arises from a suit filed by you. Just remind us once.
Suit filed by me before the trial court. We required, your lordship, the two amenities. One is the ingress and
Declaration
egress.
what was the suit for?
Suit is for declaration and permanent injunction. बोलो तुम्हें.
Declaration. Let him find out first.
Yes.
Then
Suit for declaration and permanent injunction that I am entitled, your lordship, for the common amenities which are given, your lordship, to all the flat owners in the common space, not only the gas bank and the ingress and egress.
Plaintiff injunction must be annexed here.
Yes, yes.
And the document, corporation document, which you say
That is also annexed.
we'll take the page numbers later on.
Yes, yes.
Fair.
Kindly
Your
allow
lordship,
Mr.
wants to see the prayers of the plaintiff. That's at
Yes.
page 10 of my petition. It has been set out.
Mr. Bhattacharya, please tell me, please tell us that this must be one of the units inside the complex.
Yes,
This you have purchased from the developer.
developer, yes.
Only that unit has been declared as illegal or
No,
unauthorized.
that's what they say. KMC has regularized it. I have that order that's annexed.
Only one unit has been regularized.
My unit has been regularized.
Minor deviation was
There were minor deviation, it has been regularized.
I see.
Malad, there, Lord Refuge, no? Lord Refuge.
Page 10.
Page 10 is the press. Malad, I tell your lordship what is the main dispute. The
Yes.
dispute is between the developer and the owners association with a sum of rupees 30 crores, which were supposed to be handed over by the developer to the owners association.
Nothing to do with you.
Nothing to do with me. I am caught in the crossfire. Page 10. These are the prayers in the plaint.
ওটা নয় রে।
The application, my lord.
দড়িগুলো খুলে দিন তো।
Reader. One W.
Acha, page 10 you have quoted. Acha. The actual print has not been annexed.
Actually,
Yes, my lord, page 114. Lord, that's annexure S at page 114.
Yes. So prayers at page 121.
Yes, my lord.
Right. Yes, Mr. Otto.
These are my prayers. I am asking for the amenities which are available to other occupants be made available to me. Now, my lord, what is the dispute? Your lordship will kindly see page 34. Lord, will clause 5. It's a part of the sublessor, that is the developer. It starts from page 21. It's at page 34. Shall create special fund of rupees 35 crores, lakhs. We can't think of such figures. 35 crores.
We can't.
We can't.
We can't.
We can't.
Yes.
The said special fund shall be handed over to the association after 31st March or at the time of handing over of the management. This is the real dispute between the owners association and the developer. And I am caught in the crossfire. And I have said so in paragraph 17 at page 130 of my injunction application. And also, my lord, if your lordship kindly looks at page 27 once. Common areas under the definition.
Yes.
So, my lord, the impugned order was refused on the ground that there is a arbitration agreement between me and the developer. That is of no concern. And so the first date I came, my lord, I prayed for an M gate pass, otherwise ingress and egress inside the complex is not allowed, which your lordship will find at page 39, part of the common areas, which allows entrance and exit. I'm sorry, my lord.
Yes. It does.
Entrance. And your lordship
Has to-
granted us that.
Right.
Oh, my lord, so far as KMC and other properties are concerned. And my lord will see all the facilities which I am entitled to as a flat owner. My lord, everything. I have been restrained from using any of this. Any of this. Now, my lord, so far as my flat number is concerned, there was a procedure started under section 400, subsection 1 of the KMC Act. Lord, that's at annexure L, page 88 of my petition. Bush. That numberটা কোথায় লিখছিস? My lord will kindly see page 88. My lord will kindly see after the heading PR Ambika Bedi. That's the appellant before your lordship. Detail of unauthorized construction. It is recorded, relevant record, and then the ordering portion. Authorized signatories of forum projects lodged a complaint against illegal construction at deck undertaken by forum atmosphere. Flat owner such and such, partial completion, areas, my lord. Then, my lord, page 88. PR pay, that is my client, page
89.
89, my lord, the fourth paragraph,
Please for regularization. Yes.
praise for regularization, such and such. Now, my lord,
Payment.
yes. Now, my lord, will kindly see it has been regularized at page 94. It has been regularized. So there is no order of demolition as of today by any authority. The construction has been regularized. I am a lawful occupant who has paid a consideration of about 10 crores for purchasing this flat. Now, my lord, they filed their affidavit in opposition. They referred to some proceedings between the developer and themselves. Those proceedings, my lord, first of all, my lord kindly takes their affidavit in opposition of R1. My lord, they had filed a suit against me whereby an ad interim order restraining me from transferring, alienating my property. But that order and that suit is after the impugned order. And that has nothing to do with common amenities. Well, that's your lordship will find at page 14, paragraph. কি এটা প্যারাগ্রাফ কত ও বলা আছে কত রো ও ও না কত রো প্যারাগ্রাফ কত রো to grant an ad interim injunction by way of an order dated 1st August. My lord, the impugned order before your lordship is 25th of July. Restraining the appellant and the respondent number 3 from
What are you placing?
my lord, they're pleading affidavit in opposition, page 14. Position upon one on koto botan. It's a thick.
Yes, yes. Sorry. Yes.
So,
Got it.
upon consideration, this is an order of 1st of August. The impugned order is 25th July. Considering the submissions of the said IBG infra properties, the learned first court at Alipur was pleased to grant a temporary ad interim injunction by way of an order dated 1st August, thereby restraining the appellant and the respondent number 3, which is the developer, from creating any third party interest or from carrying out or dealing with or from changing the nature and character of the apartment being such and such. This is my apartment. A copy of the order is annexed. Now,
Is E101 is yours?
yes. Now, my lord, they were all along aware about my flat. That would be evident from their own document, which they have disclosed, which is at page 57 of this opposition. If your lordship kindly, it starts at page 57. If your lordship kindly comes to page 64.
57 of opposition. This is
57, it's a document of sublease. 57.
no, this is RERA order.
Something else.
No, no. I'm sorry, my lord.
That's very important. The RERA.
No, 57. My lord, এটা কিসের তাহলে? My lord, I think that's with my reply. I'm sorry, my lord. Page 57. I'm sorry, it's with my reply. I'm sorry.
In May 2026.
2nd May 2026, it has been affirmed. It starts at page 57 at page 64.
Yes.
Has purchased this property.
And this is by IBG Infra. If your lordship looks at page 62, the parties to the agreement, page 62, Forum Projects and IBG Infra.
That is a developer.
Forum is the developer. IBG Infra is the plaintiff in that suit where that order of 1st of August was been passed. My lord kindly looks at recital I at page 64.
Yes.
The sublessor has got approval and sanction from the Kolkata. Sublessor means the Forum Projects, the developer, from Kolkata Municipal Corporation on a building plan such and such for construction of the said complex, and further received revised sanction plan dated 5th November 2018 for construction of the complex. The revised sanction plan talks about my flat. Lordship will also find that at page 111, similar clause. Now, my lord, there was a litigation between one of the flat owners and the developer. And there is an order of Justice Sen, division bench presided by Justice Sen,
Which
which
clause
is at
that page 111, sorry?
my lord,
111, which clause?
my lord, 111, my lord, same. I. The last one. The sublessor has got approval.
These are just page 107, page 107.
100, I replied.
111 is a part of 100.
107.
107, another lease.
Someone else.
Someone else.
That's not relevant then.
Yes, it's not relevant actually.
The revised sanction plan includes my area.
Yes. Now, my lord will kindly take an order of Justice of the division bench, which we have annexed at page 162. I was not a party to that.
Yes.
Now, my lord, paragraph 3 at page 163, the learned has made extensive arguments with regard to the scope, the sanction plan, as well as the modified. I'm sorry, my lord.
No.
At 163, as well as the modifier. Having considered this, it appears that the present respondents purchased the property with the knowledge of the modified sanction plan on 5th November, on the basis of which certain constructions have been undertaken. The pictures produced before this court have shown that substantial construction has taken place with regard to the construction of the penthouses. Mr. Esan, such and such appearing, has contended that the respondents were under the belief that it was constructed for the benefit of the residents, and in any event, they were under the impression that their access would not be affected by the said construction. Then, my lord, paragraph 5. In view of the fact that substantial construction has already taken place and the modified building plan has not yet been revoked, prima facie, the appellant has the right to make construction of the penthouses. This, however, is subject to any proceedings that KMC might initiate or contemplate, or any such construction shall abide by the result of arbitration proceedings. I am not a party to such arbitration. In the event it is constructed, is transferred, alienated, shall not be entitled to claim any equity in the event ultimately it is held. Then, my lord.
So this was between some other parties. Why
Yes, yes. No, my lord, paragraph 7. Your lordship will kindly see. This was all along known to them. All along known to them. My lord, paragraph 7. Mr. Such and such learned.
What was known to them?
My lord will kindly look at paragraph 7. For the appellant has submitted that the constructions was made beyond the said area. And in fact, one of the constructed flats has been sold in favor of Ambika Bedi. It is needless to mention that in the event it is ultimately found that such construction was beyond the agreement or sanction plan or the modified sanction plan, the petitioner shall be entitled to seek relief. So they knew there is a construction and this flat has been sold to me for consideration. There is no order of demolition by any competent authority, rather it has been regularized. Their prayer is that I am declaration that I am an illegal occupant. My lord also kindly takes the memorandum of association of the flat owners, which is at page 28 of this opposition, of the reply. I'm sorry, my lord, of the reply.
I'm not very sure whether these documents were there in the trial court. I'm not sure at all.
No, this was after affidavits.
That's what I'm saying here.
Your lordship, what happened, I'll tell your lordship. That time SIR was going on.
No,
And-
Mr. Bhattacharya, please confine yourself to whatever was before the trial court.
But your lordship gave directions that your lordship will hear out the appeal.
That did not mean that
Yes.
we permitted you to produce documents. Which
But
are
they
not
have produced in opposition.
even then. None of you can produce documents which are not
So
before.
but then that's fine. Then it's fine. Then it's fine. They were aware about my construction. It has been regularized. My lord, as per RERA,
This is from an ad interim.
ad interim.
Expert ad interim.
অর্ডারটা দাও যেদিন আপিলের অর্ডারটা দাও যেদিন অ্যাডমিট করলো না না অ্যাডমিট করলো অর্ডারটা ফার্স্ট অর্ডারটা অর্ডারটা দাও मतलब
There's just one thing, Milord, may I just indicate before my learned friend begins, Milord, 5th September is the next date of hearing in the trial court. Milord, what he wants, Milord, is basically an ad interim mandatory injunction, which is very difficult. In my respectful submission, he has to show a grave case, Milord, where he can't live or something like
Mr.
that.
Chatterjee, it's an essential service.
Well, I'll tell you, Lordship, what the
They are in
problem is. I'll cut it short as much as I can. The problem is that the flat that Mr. Bhattacharya Milord occupies was not a part of the plan. Your Lordship will see, Milord, E-deck was a plan where, Milord, it would have been a green place,
But
which
Mr.
was a
Bhattacharya-
common
Mr.
place.
Chatterjee, but there are judgments in under Electricity Act, you know that.
Under Electricity Act, yes.
Lawful. So
In a possession, I
and
understand.
that also connects with Article 21.
Milord, I bow down.
Who is
Now,
different.
it is not that, Milord, this is Article 21, because why I tell you, Lordship.
They are prima facie
He
shown that
says,
there's a regularization.
gives me 1 minute's time, Milord. Regularization, but RERA has stopped me from doing anything because of that. Now, what happens here, Milord, if he wants it from the gas bank, Milord, the construction is such that there has to be, Milord, a pipe which needs to be constructed. That pipe needs to go, Milord, into his, Milord, premises, and then he gets that. So that is a mandatory injunction of a different level. It's not that he can't live without it. He has his cooking places, he has whatever he has. And Milord, he's here for years together. It's not that he's come in, Milord, today. He's there, Milord, for years together.
what is his difficulty?
Only one question. Is it not the fact that he purchased the property from the developer?
Yes, Milord. But that's where the
It is
other
not the
owners
case.
agree.
It is not the case that he has constructed the flat over there.
No, Milord.
He has
that's
purchased the flat.
Milord.
Now, at present, please tell us the situation, whether the association is managing the entire affairs or still the developer is managing the entire affairs.
It's the association.
Association is so all the duties and liabilities of the
Not
developer.
the amenities. Duties and liabilities is one thing. Not, Milord, the amenities.
The bona fide purchaser, where he will go?
Milord, he is there. He's enjoying the property.
No, this is essential amenity.
But
Where he
it
will
is
go?
not
He
that-
has
Milord, it's
purchased.
essential.
He has purchased the property
I
from
bow
the
down.
developer.
Milord. I understand what's going
If the
through your lordship.
association now, if you simply brush him out, where he will go?
I completely bow down and understand what is going through lordship's mind. Milord, there is a difference between an essential community, essential amenity and an amenity. Milord, if he didn't have electricity, I would have understood. Gas is not, Milord, an essential amenity. There are other things by which he can cook. Milord, in his amenities portion,
No, what
gas
amenities
connection is not
everyone-
given.
What amenity? Is it a case that he is not paying the common area maintenance charges?
Well, I offered, I tendered, they returned.
He has it because
No,
he's
I
used to
offered,
not
I
an
can show it.
amenity.
গ্যাসে রান্না করবো
হ্যাঁ, সেই তো।
আরেকজন এসে ইন্ডাকশন করে রান্না করবে
Electricity machine.
কোথায়?
Now, my lord, Kindly, my lord, may I ask this question to myself? Kindly ask Mr. Bhattacharya when he purchased the property.
Whatever,
My lord, your lordship is today on ad interim. My defenses, my lord, are not there. They've suppressed a lot here. Entire orders of RERA, everything, they have suppressed it. My lord, what right is he claiming? Today, my lord, under RERA, they can, my lord, even ask for demolition. RERA, my lord, an entire tower has been asked to be demolished because, my lord, there was, even with a sanction plan, because what was told to the buyers was that this part, my lord, your lordship has seen atmosphere. There are two, my lord, buildings like this.
yes, connected
There,
with Calcutta.
yes, my lord. And then there is a connection here, my lord, by which there are bridges, one here, one here. They have, the developer, they have, my lord, converted this connection into his flat, into his apartment, and which is in direct contravention, my lord, to the plan which was given to us. Then, my lord, what happens is, in his deed, gas connection is not given to him. Have a look to his deed, my lord. In the amenities section, gas connection was not given to him.
Like, generally amenities are given gas
So
connection.
these are amenities which are, my lord.
Whatever amenities others are.
Problem is, my lord,
You have to
I-
see in that light.
absolutely, very well, looks to that as well. Asks the developer, my lord, whether they can give him that. Because this gas, my lord, if your earlier days, my lord, we had that Greater Calcutta gas supply where everybody, whoever had the connection, for that, my lord, an infrastructure was required. This building is built in such a manner, my lord, that the infrastructure with respect to gas, that pipeline will not go to his place. Today, my lord, if your lordship grants me an ad interim mandatory injunction, then the entire, my lord, the entire building is in jeopardy.
That is the best part of your defense.
It is.
That is the best part of your defense.
The entire
No,
building
it's
is in jeopardy.
So,
So this can't be, in my respectful submission.
So, but you address that also.
Yes, my lord. First of
Give
all,
the nature of a mandatory
my lord,
injunction and
my lord, your lordship had considered this while passing that order. My lord,
So
kindly
that was
takes
for
the
our
order of 6th of April. Why after affidavit it's being heard by your lordship over here? Your lordship, I had relied on a decision of the Supreme Court, and your lordship was satisfied and asked them to grant me the M-Gate pass, and
Yes, given.
kept question with regard to gas
The
connection.
exit is on a different level.
The gas, now it is gas. Yes, my son has
Gas is also on a different level, but on a lower level.
has another flat. My lord will kindly look at the definition of common areas under RERA. And please ask Mr. Chatterjee if my client is a party
Stop
before RERA.
asking us to ask each other, please. You see,
My client is
He'll ask
not a
whatever you have.
my client is not a party before the RERA
Whatever you
proceeding.
have to submit, he'll submit whatever they have, and we'll ask for.
My lord will kindly see 2N5
Yes.
RERA. Because common areas in none of the agreement is defined, it is under the RERA. Installations of central services such as electricity, gas, water and sanitation, air conditioning. I'm sorry. 2N5.
Yes.
So it is a basic necessity. Part of common area.
This is the central service given from
Yes.
the central bank sort of
Yes, there is a gas bank, my lord,
gas bank.
from which it is supplied to the units.
So vis-a-vis this particular apartment, it has to be taken as an essential, I mean,
Common area.
one of the common.
Common area, and I'm entitled to this facility. I am not a party to RERA proceedings. There is no order of demolition today. There has been a regulation by KMC.
Now, one other aspect, Mr. Bhattacharya, at this ad interim stage, when the main matter is fixed on 5th of September or whenever, this is in the nature of a mandatory injunction in the sense that if there was an existing connection,
I understand, my lord. I understand. I can rely on that same decision which I had cited at an ad interim stage.
Do that, please.
Yes. No,
On that point, we have some doubt.
Yes. If your lordship kindly considers your lordship's order of
Very
so 6th of April 2026.
good.
57 to 59. But I knew I would be posed with this query because, my lord, we know those line of cases, Nandan Talkies and all, 51 Calcutta, that not Nandan pictures, that ad interim. But
By now
that
it has become a
now, my lord, those principles have now been diluted. My lord will kindly see the contentions, your lordship,
the 6th of April order.
6th of April, my lord.
Yes.
Lord kindly looks at
Para 13. That one.
paragraph 13. Yes. I can hand over the judgments once more, my
Is
lord.
that no?
Yes, I have to copy as well.
এটা ছিল তো না না it was there. Yes, it is there. File আছে.
2019-14 SCC.
Yes, my lord. May I hand up a copy, my lord?
No, need not multiply copies. We're already overburdened with too many papers. Yes. There are 57, 59.
57 to 59, my lord.
Yes. Let's check it out.
Then paragraph 14, the regularization order. Then paragraph 16. And then paragraph 17, basic amenities. The lordship looks at basic amenities.
But that is always there.
Then paragraph 18, your lordship held that whether there is a agreement or not. But under RERA, I am entitled. And my lord, why? Directions for affidavits were passed, your lordship will find at paragraph 21.
The existing grid of pipelines don't permit giving you an electricity connection. That's a specific stand taken by them. If you have to,
My lord, in that case, your lordship can appoint any engineer to go and find out if
that, Mr. Bhattacharya, would be probably a bit too much at this stage, particularly since the main matter has been fixed.
my lord will kindly look at paragraph 21. My lord, I've been waiting since April for this. My lord will kindly look at paragraph 21.
Written objection to the injunction you have filed already.
Yes, yes. I have filed.
They're fine.
It was their injunction. Your yes.
My instruction, it has not been filed by them. Because, my lord, the main matter.
Ask for a copy, Mr.
My lord,
Chairman, it will be clear. Ask for a copy of the.
My lord, the main matter.
You can
Ask for a copy.
My lord, I'll tell you why they did not file it. Paragraph 21, if your lordship kindly takes.
They will do it. If not within
My lord, paragraph 21, your lordship looks at it. However, such course of action is not feasible at the present stage.
Yes.
In view of most of the judicial officers of different districts have been engaged as per, then thus we take it upon ourselves
No, that was because of the essential, sir. My lord, the written statement has been filed. Written objection has just been, my lord, given to a written. The injunction application has also, it's ready and it will be filed, my lord, in a day out.
My lord will kindly see, and that's why your lordship entertained this appeal and directed them, paragraph 22, to file their opposition. And accordingly, this was done. So what is the difficulty if this connection is given to me?
So anything else, Mr. Bhattacharya? We
No.
conclude
My lord, even the structure. दस करोड़ देके खरीदा है तुम उसको ये भी नहीं करने दोगे আমার কাছে 10 কোটি আমি আমার 10 জন্মে দেখবো না
Yes, Mr. Bhattacharya.
Yes.
Anything else you want to?
So that's why the directions were passed, and my lord, they have filed their opposition. I have filed my reply,
So let
and
us
as per the reply, my lord, I can show that their memorandum,
Yes.
my lord, will kindly take the reply once, page 28.
What do you want to show?
My lord will kindly see their memorandum of association talks about giving gas connection,
Let us see that. Yes.
page 28. Because this is a section 8 company. This is the memorandum which they had to file before the ROC. Page 28.2. Your lordship kindly takes 28.2. At page 28, clause 2.
Yes.
To keep and maintain the open and covered and parking areas and open space, common lighting of residential building, forum atmosphere, and its common areas, common parts, and common portions, including the outer walls, staircases, terrace, roofs, pump roof, lifts, machine room, including electrical rooms, telecom, Wi-Fi, security rooms, store rooms, and overhead
We have
water
reached-
tanks.
we
My
have-
lord, my lord.
We have reached pipelines.
Pipelines, yes,
Please
I'm grateful to my lord. And septic tanks, garbage areas, electrical, power,
Garbage is garbage.
Garbage is
Forget the
garbage.
garbage. We have reached the pipelines
Excellent,
at
Dharma.
substations.
power transmission,
Don't have to read
distribution, such and such, water lines.
And you are reading it for the first time, Mr. Bhattacharya, but you have read.
No, my lord, it's marked. It's marked. It's
But yes, we've got the pipelines.
yes.
Even if you
And
have not got.
other, my lord, will kindly come down a little bit. Areas used by occupiers, owners, occupants, users. I am an occupant,
Yes.
so I am entitled to this as per their own memorandum itself.
Modulation. It's admitted that you are an occupant. But modulation in the voice. Occupants is the
I am an owner occupant.
Both.
As per their own memorandum, I am entitled
User
to
also.
this.
User also.
User
staying
also.
there.
No, they are not letting me use it. None of the common facilities.
No. User of the you're the user of the flat.
Yes,
Unless user occupant and user are interchangeable.
yes.
The flat, not the pipeline.
Not the pipeline. But I, as a occupier, user, owner, I am entitled to this.
That is what we said also.
Swimming
well, let
pool
us
use
hear
করতে
this.
দিচ্ছে না, no? Well, even the kids are not being allowed to use the swimming pool.
I think that is
Well,
beyond
ask them to
scope
put
of-
the gas pipeline into the swimming pool so that nobody can use it. So your purpose is served, their purpose is served, and our purpose is also served. The hearing is over. Yes, Mr. Chatterjee. Quick.
বাচ্চাদের সাথে
Minus the swimming pool.
My lord,
Yes.
we've never seen my lord, never been to an apartment which has a swimming pool, so I
Well,
wouldn't know.
Oh, great.
I wouldn't know.
if you start with an untruth, Mr. Chatterjee, we'll be very cautious whatever you argue next.
It's true. I haven't been, my lord. There is no dispute on that.
You haven't been, you haven't taken.
I haven't taken, I haven't been, my lord. I don't know what Mr. Thakkar. Mr. Bhattacharya definitely has gone, my lord. There's no dispute on that. Mr. Thakkar is too big a miser, my lord, to go to such apartments. He will not go. Now,
Yes,
coming back to
very
the matter.
apparent from his demeanor and otherwise also. Mr. Chatterjee, anything else you want to add?
I have got very little submissions. Well, my Mr. Tucker wants to make his submissions. He'll make that.
What do you mean by that?
But he's appearing. He's a senior advocate.
Then we'll hear him directly.
I just 2 points I'll make, Pilot. Thereafter he'll take it up. My respectful submission is, Pilot, this is not a situation where without this he can't live. My gate was.
Not essential, you said.
I'm saying, Milord, that this is not something.
See, Mr. Chatterjee, we are making it very clear regarding the M gate. We are not modifying.
We have given.
Yes, we are keeping that.
We have given.
Entry and exit, we have.
We have given. We have not. Milord, your lordship wanted
We are
us
hearing
to
on the gas
just
connection.
gas.
Only the gas connection.
Yes.
Milord, the gas needs an infrastructure. If the gas doesn't have an infrastructure, Milord, by way of an ad interim mandatory injunction, and it's not something, Milord, which is simple. Milord, if the connection was there and it was not given to him, I would have understood that completely. He cites a decision, Milord. Kindly have a look at that decision at 57, 58, and 59. There was a gentleman, Milord. He was removed from his possession and he was brought back into possession. Wrongly removed. That is non-known pictures. Why, Milord, go into anything? I'm completely bowing down there, Milord. That's not the situation here. Milord, it's a dangerous situation if something happens in the gas line. This is a combustible substance where the entire building will be in jeopardy. So it needs to be taken, Milord, very, very seriously and in a very, very, Milord, cautious manner. So what he says, what he wants to get everything in the ad interim stage.
That by itself cannot be a deterrent.
No. I'm not, Milord, I'm.
Because whoever, if some new person comes tomorrow,
bow down,
the
Milord.
line has to be given.
That's what I'm saying.
What has to be done has to
New
be done.
person, Milord.
Whether we shall do that at this ad interim
Yes,
mandatory.
that is, Milord, I
this
don't
stage.
need to, Milord, go on with it
That
at
is
all.
what we have to consider.
At all, because that's why I'm saying, Milord, that if it requires certain amount of, Milord, adjudication, and it is not something by which he can't live in that property, like an electricity or something.
Not essential, no infrastructure is there, therefore mandatory. Mr. Tucker, yes.
The common areas are to be provided by the developer. The developer has sold him a flat which does not have this. That is the obligation of the developer. 4A, my learned friend.
Respondent, Mr. Tucker?
Respondent 1, my learned.
One. And you are for? Oh, both are.
Sorry.
Very good. Common areas?
Common areas definition was relied on as in the act. Kindly see the common area is the obligation of the developer to provide. 11.4A, the developer has given him a flat which does not have the connection.
And no infrastructure.
Because it was constructed subsequently.
All right.
It's for him to pursue his developer for whatever remedies he has.
Developer is not in control.
Developer is there. He's there.
No, here physically, we are in control of the developer.
No, for
Of the
construction.
developer's advocate to be
That-
precise.
I'm sorry, Malal, for construction now,
Yes.
association cannot be compelled.
Developer has the right to make constructions now also.
Malad, he still has units there. That is why he's fighting in the RERA. There are other unsold units.
Can we record your submission then if the developer gives them this
No,
gas
Malad,
connection, he's entitled to it?
No, he is not entitled. He cannot have a grievance against me. He cannot have a grievance against me for not providing him. That is a short submission.
No, he cannot be UVGI's IB remedium. But if
No.
the developer can't give it to him,
No, the developer
then
is
we have
party.
to consider whether you have to give it to him.
The developer is a party to the proceeding.
If you say so, Mr. Tucker, we can direct the developer to give him directly.
Sorry to interrupt.
But the
I'm sorry to
developer
interrupt.
cannot, Malad, it is a developer's obligation to provide him. When the gentleman bought the flat, when he bought the flat,
It was not given.
he was not given.
He
That
cannot
is-
be
that-
deprived for eternity
No,
for
he
that.
cannot be deprived. But that is why, Malad, the larger picture is about the existence of this flat A, which is subject matter of various pending litigations.
And he will have to pay for whatever the infrastructure requires.
Correct. Malad, that is
So what is the difficulty in giving that?
no, Malad, the difficulty is this A, two things, Malad. The difficulty is twofold. A, my respectful submission is it is not something which Mr. Chatterjee said he has the right ingress because there's no difficulty. He can take his gas cylinders and go. That is not prohibited. Without there's
The others can also do that.
no, Malad, that is why the infrastructure is already existing for the others.
Infrastructure.
sorry to
is-
interrupt.
Mr. Chatterjee, no. Please don't do this. You are feeling very disturbed.
My mistake.
If the infrastructure is there and other people are having it, Mr. Tucker, why shouldn't one person have it? That
Because
is one of our considerations also.
I follow. Malad,
Just like you have got a very good point in saying that at the ad interim stage, whether we should grant this mandatory, that's there in our mind. But at the same time, I mean, they are on equivalent footing. They are also an occupant. They
yes.
are purchased by paying money.
Yes.
Developer, because of the sins of the developer, you are punishing him. This is not done.
No, Malad, it's not the sins of the developer. If an occupant or you purchaser of a unit He is satisfied with the unit in the condition in which it is. He has purchased it. It's not that he walks into the unit the first day. His son is already there having a unit. It's not that he's a bona fide purchaser for valuable consideration without notice.
He knowingly purchased.
He knowingly purchases a unit. It's not that he is for holier than thou. And the common area reliance on, I'm only on the common area reliance. That is.
Do you have any idea, Mr. Thakkar? You can take instruction on that, whether there is any other unit which does not have gas connection.
Only unauthorized.
All the unauthorized construction.
Our question is
Only.
yes or no.
Yes,
Is there any other unit which does not have gas connection?
nobody. On the E-deck, nobody. Lord, if your lordship
Is there anyone in the entire building who does not have any gas connection from the grid? Any flat
You have to find
which
out.
does not have.
You have to find out. Everybody has.
Ask your
The client.
whoever
will
is
have to
instructing.
source it.
Don't threaten us.
No,
Take
not
this.
threatening, my lord. I just
No, no,
took
physically don't
instruction.
threaten us. Please
No,
take
no.
this seat.
Blood, what we know is that on that E-deck, whoever the flat owners are, they have no Milord gas connection. Because
This is not the only flat in that E-deck.
no, there are
The other illegal constructions, which according to us are illegal, may be legal. That will be decided by RERA. Ultimately, the
So none of them has this gas connection.
no E-deck doesn't have a gas connection. Milord, if your lordship sees, Milord, the deed, E-deck is Milord defined as a green area.
Yes, yes, that
It
is.
doesn't, then nobody needs a gas there. But what the developer did is, man.
So conflict arguments now. Mr.
yes,
Thakkar.
it's just very short.
Conflict
So, Malad, on common areas, that is that only for that purpose I drew your lordship's attention to this fact that he has bought something which did not.
knowingly purchased, developer did not give
Did
him.
not give him.
took
It's
the
a matter
choice,
and he
took-
cannot get a better right today.
Good.
A. B, Malad, he is not a member of my association. He offers to become, but I am entitled not to admit him because I do not recognize the legality of his occupation. And that I cannot be compelled to do till this matter is resolved. So asking me to provide services to him today, where I dispute his legal status.
These are not very strong points, you know,
No,
Mr. Thakkar.
Malad, at
Because if you say that the moment one says that he's not a member of my association, that's why I won't give him an amenity. Then we have a temptation, the courts have a temptation to direct
Malad, this is
whoever
at the
else
ad interim stage.
give that
At the ad interim stage, your lordship is
take
no,
that from
Malad, your
other
lordship
authority.
at the ad interim stage.
An association cannot strangulate a person who is
Of
deciding.
course not.
This attitude we
No,
fully deprecate.
No, at this ad,
Utterly deprecate.
no, at this ad.
I'm the association, you are not my member, therefore I won't give you. Don't give it, you'll direct the developer to give.
No, Malad,
This
kindly
cannot
do
be
not.
a good ground.
No, Malad, kindly do not take. I only say this, Malad.
Your choice.
He-
Somebody is not a member of the bar association, Mr. Thakkar. I won't permit him to enter the
No,
courtroom.
no, it's not
Very
like
well, you don't permit, I will like the police to permit.
it's
it's
not
like
no,
that.
Malad, I think I have not been able to
This
express.
is on a higher footing.
I have not been able
Gas
to express
connection
myself.
required for cooking.
Malad, I have not been able to express myself.
Hmm.
All that I was saying is
You have no liability. We understand.
we have
We
no
won't
li-
direct you.
Yes, we have. Malad, I did not express myself correctly.
Hmm.
We do not restrict him from taking LPG cylinders to his flat. That is all that I see.
But you restrict him from taking gas connection.
We do not restrict him. He doesn't have it. I would have understood if the supply, there's a distinction between a supply being there and the cock being turned.
That is the first argument made by Mr. Chatterjee.
That is
you
all.
add some. You are
Nothing.
Mr. Kaur, you want to add something?
I think everything is added.
So we deem it to have been added. Then.
Yes,
No. Who is appearing for the developers?
developer, I don't know.
Developers.
Mr. Thakkar was all along showing that side.
No.
No,
They would know. What are
the
the
service provider, we have, that service provider
Provider,
is
sir.
there. Because the service is provided by a different service
Third
provider.
party.
So we were inquiring whether the property is still under the control of developer. Developer has some control over there.
Developer has no control for us except for the 3 new flats which the developer was constructing,
And there is litigation.
which has now rested not because of the proceedings before the RERA. And Lord, there is an arbitration proceedings where status quo has been directed to be maintained.
Just now,
including the
Mr. Thakkar told that some of the units are still held by the developer.
The 3 units, which
These units.
these 3 units.
First,
Apart from that, there is no control.
first sanction plan contains 80 flats. Now, Lord, they applied for a revised sanction plan. Based on this alleged revised sanction plan, which is under challenge, they have started building 3 new constructions. One on the E-deck and Lord, 2 on the roof. That roof thing is not complete yet. They are still pending. So far as this E-deck is concerned, the developer has been able to part with possession in favor of my learned
How
friend.
many units are there in the E-deck?
E-deck, there is only 1 unit. They have
Only this one?
constructed. This one. This one. This is encroaching upon the common area. This flat has been.
Chatterjee told there are other units also.
According to the sanction plan, Lord, there were no flats on the E-deck, original sanction plan. Then Lord,
I was correct.
Therefore, there is no other flat which does not have a gas.
Chhade duto acha. I was correct in the
at the roof terrace, they have, yes, there are three additional units, Lord, that they are constructing. One has been completed on E-deck and the
The association is in control of the E-deck otherwise.
E-deck otherwise, common area. And our contention was before the RERA that without our consent, this construction couldn't have happened. And that is the reason, Lord, we have gone to RERA, because while registering the project with RERA, there was misdeclaration before the RERA. And Lord, there are Lord, the fact that there is no gas line connection would also appear from a letter which is at page 76.
That was there in the trial court.
This was there in the trial court. If your lordship looks at page 76
Of
the state petition.
There is no abandonment in the field also, there is infrastructure.
Lord, kindly see, this is a letter written by Ombika Berry. It's in the first volume, Lord, of this state petition. Page 76. I have attached the drawing for taking the gas pipe to the kitchen in the E-deck apartment as suggested by the fire vendor. I feel this is the best way, as taking the gas line from the inside the house will not be safe.
This was written to your persons.
Yes. I am sure Forum as well as Sila will agree to this. Sila is the other service provider. If you can suggest an alternative, please do, as we need to get this done. So thanking you, waiting. Lord, what had happened when the original plan was sanctioned, the infrastructure of the gas line was constructed at that stage. Now, Lord, these additional, Lord, constructions which have been made, which are being, one is made, the other is in the process, where, Lord, the RERA intervention, etc. There, Lord, the gas pipe is not there. The infrastructure is not there. Because, Lord, it was meant to be common area. Now, this is her own letter, which is annexed to the state petition, where she says that pipeline has to be drawn.
Yes, Mr. Kaur, anything else?
There are two other things, Lord, which I wanted to point out.
Please don't re-argue what they have argued. They have already argued at length.
just I just touch on this, Lord. I will not go deep into
Yes.
it. Lord, there are proceedings where, Lord, the order of status quo in respect of EDEC has also been passed. This is, there is a civil court order and there is an order passed by the arbitrator where, Lord, the developer is a party under section 17. Because, Lord, the issue is also in arbitration apart from being RERA. And section 17, there is an order of status quo. I'll just give the page. I'll not.
Arbitration between them and the developer.
Developer, no. Between, Lord, some of the flat owners and the developer. They have derived their title from the developer.
Alright.
In respect of EDEC, Lord, there is an order of status quo passed by the arbitrator as well as a civil court. So, Lord, these are the two orders which I would just.
This is on the argument that that construction is illegal.
Construction is illegal and, Lord,
That
the
is sub judice before the
sub
appellate
judice
authority,
before the both before the civil court as well as the arbitrator
appellate authority.
and the
The
developer
appellate authority also probably.
and the appellate authority. Apart from the appellate authority, these are the three authorities which are dealing with the matter. And, Lord, the before the arbitrator, Lord, the developer is a party. Developer is also a party in RERA. Developer is also a party in that civil suit.
Mr. Mustari, you wanted to, Mr. God, please.
Yeah, can I give the page number of the order passed by the arbitrator under section 17? Just the page.
Yes, yes, sure.
The section 17 order, your lordships will get at page 58 of the affidavit in opposition of the
One.
of the respondent number 1. Yes. Lord, page 58 at page 79 and 82. Your lordships will find the order of injunction is there. And, Lord, so far as the interim order passed by the civil court is concerned, that is dated 1st August 2025, page 86 and 87 of the same affidavit. And, Lord, your lordships will kindly, Lord, take note of paragraph P for Patna, page 14-15, paragraph Q, page 15-16, paragraph R, page 16. Lord, much.
Yes.
Two things.
Want to add something? Just add
No.
that and
First of all, that 1st August order, I had only indicated that was after the impugned order. My lord, so far as Mr. Thakkar's contention that the developer was to provide it and it is in the agreement, it does not provide for it. In none of the agreements it is provided for. But I have just received instruction that this meter is inside my flat. The connection needs to be switched off for 1 hour so that it can be connected to the pipe. Now, this is the picture. It is inside my kitchen.
what is inside your kitchen?
This meter,
Gas meter.
the gas meter. My lord, this is the picture. I can just show it to your lordship.
Not a part of the
My
record.
lord, it just needs to be connected to the pipeline.
Did you make out that case anywhere?
Have we made out of that case?
Show us.
My lord, there was a letter. I can show that letter with
Anywhere, anywhere.
104 of my petition. Page 104 of the stay petition, my lord, kindly.
Yes, Mr. Bhattacharya, 104.
This is the service provider's email to me.
Mhm.
We regret we had written to the service provider for the inconvenience to unable to switch off the entire common gas line of East Tower apartments, owing to residents using the gas line seamlessly for cooking purpose. I said, for 1 hour, if you just switch it off, that the pipe can be connected with the meter.
Your
20
kitchen pipe with that meter.
Yes, that's it. However, we have informed the executive committee of the association to grant permission on gas line work while checking the convenience with the residents of the East Tower. 1 hour, how would it inconvenience them?
Was it there before the learned trial court?
My lord?
Was it there before the learned trial court?
Yes.
This is a part of the injunction.
Yes. Yes. 1 hour it will only take.
How are you making do in the meantime with gas cylinders and all?
No, my lord, gas cylinders are not allowed. Possibly my learned friends don't know that where there is a gas bank, gas cylinders are not allowed.
Oh, acha. You will not get that supply.
No, gas cylinders are not allowed wherever there is a gas bank. खुजे ना, खुजे ना. Just because my other son has another flat, that I will be deprived. Today my son decides, no, I will not allow you to come and eat and cook. Where do I go?
Where is the corresponding averment to annexure Q?
Kindly gives me a moment. কোথায় বলেছি? Annexure Q. Paragraph 25 at page 9. Page
No,
no.
this is the present application in the trial court
Trial
injunction.
Trial court. My lord kindly gives me a moment. But this was there before. The kindly gives me a moment. My lord.
Para 24, page 132.
Page 132, paragraph 24. Paragraph 24, page 132. Linked annex. The petition of the stay petition.
Pipeline. You have not even asked for a pipeline to be given. You have said that. Let us see how the injunction was called. Yes, mandatory injunction was there, but to forthwith provide gas connection. That can be either way.
Mandatory change. 123.
ट्रेन नहीं तो
It is the plain. I didn't much plain. Where is the petition, my lord? At page 135. B and C.
You have not stated anywhere that there is an existing infrastructure there in your flat.
That
specifically not.
That's specifically not. I have given the correspondence. It's where I have requested that you just switch it off for an hour so that the pipe can be connected with the meter.
We'll close arguments on this one. Reserve
Great.
judgment on this one.
Great.
Hearing is concluded. Full stop. The matter is reserved for judgment. The appeal and the
That's it.
appeal are reserved for judgment.
Okay. Later. Yes.
এটা আমারটা একটু
আরেকটা আছে আরেকটা আছে কপি এই আমার আরেকটা কপি আছে কালকে বসে আবার করেছি ওই যেটা বলছিল আইডিটা ভুলভাল বলছে দুটো জাজমেন্ট বের করেছি
Parted with the other.
Huh?
Yes. List the matter before the bench before which it was heard in part.
সব বাবা ভাবলাম নতুন হুজুরের কাছে একটু
Next.
বকুনি টুকুনি খাবো
Yes.
মানে there
Say
was
what?
a gap of 2 days, my lord, because unless it is published earlier.
No, no,
7 to
7 to 9. Your lordship, part heard matter before the regular bench. Your lordship,
Before this bench.
regular bench.
Now it's an irregular bench. So the same order as the previous one. To be listed before the bench which heard the matter in part. Same order.
Grateful, your lord.
May it please your lordship.
My lord,
Yes.
item number 10, we received the supplementary documents yesterday. Moreover, the
Sorry, ma'am. No time.
learned counsel not well, therefore I prayed for
No.
this week.
Appeal first hearing matter we don't grant adjournments. We will hear Mr. Shen and conclude arguments. Sorry.
It's very short point, Lord.
Yes.
Lord, two suits were filed. Lord, one, Lord, I appear for the landlord. Lord, one suit filed by Lord the lessee, claiming that the deed of lease on the basis of which Lord they were in possession is not enforceable, and for a declaration that they are not governed by the Premises Tenancy Act. And a suit filed by us as landlord for eviction on the ground of expiry by efflux of time 111A. Lord, both the suits are heard analogously. Their suit for declaration injunction is rejected. My suit for ejectment is allowed. Lord, subsequently, Lord, I've initiated title execution case and I've received possession. Lord, that has come to an end. Lord, the defendant, the tenants, the lessees filed 2 appeals, but Lord, they have not even been admitted before the stamp register. So, Lord, we are really not concerned with that at the present moment. Lord, my grievance is Lord with regard to the decree for mean profit to the extent to which it has been allowed by the trial court. Now, Lord, insofar as the plaint is concerned, in the plaint, Lord, I have pleaded that this is a flat about 1426 square feet, 3-bedroom flat in Middleton Street. Lord, the lease deed on the basis of which Lord possession, Lord, I had sought eviction was for Lord a period of 2 years where the rent was 33,000 rupees per month. So Lord, approximately 33,000 per month divided by 1426 comes to about rupees 23 per square feet per month. Lord, be that as it may, Lord, in the plaint, I have claimed mean profit at the rate of rupees 500 per square feet per month. Lord, my witness has, Lord, in his evidence, Lord, affidavit of evidence was filed. He has also said 500 per square feet per month. Lord, there is no cross-examination. Lord, in the decree, Lord, as your lordships are aware, Lord, either decree can be passed or Lord, direction can be given for determination under Order 20, Rule 12. Now, Lord, the learned judge passed a decree for 500 instead of saying 500 per square feet per month, which I presume he must have intended, said 500 per month. But I'm not saying that 500 per month is what I would have got had there been a determination. But not my plain case is 500 per square feet per month. This is the evidence which I led. There is no cross-examination. The decree it says 500 per month, which becomes an abysmally poor amount. That's one part. And the second part is not the mean profit was given only not till the date of the judgment, Lord, and not till the date of possession. Lord, I would believe, Lord, in my respectful submission as a lordship's officer, that Lord, there ought to be a determination. There ought to be a determination.
Mr. Shen, we can do this. We can just
A limited remand to this.
set aside this judgment
Only
pass
to
a
the extent of the mean profits.
to the extent of the mean profits. This
Yes,
arises from the same eviction suit itself.
Yes, Lord.
The other component of which has already been satisfied.
Yes, Lord.
So we are only this part of the decree where because the final degree of mean profits has been passed at the first instance.
Yes, Lord.
We set that aside. We grant a preliminary decree and direct a determination under order 22.
My Lord.
Look, it would look odd. Such a short judgment in a first. It will be very short. There's nothing to determine here. Can you see the impugned judgment?
Yes, Lord. Lord, please come to page 100, Lord. And Lord, page 100 it starts. Lord, I assure your Lordship that till page 123, where the ordering portion is there, Lord, there is no reference to mean profits at all in the judgment of the trial court. Till the ordering portion at page 123. Lord, please come to 123. TS number 504 of 2013, which was a lessee's suit, is dismissed on contest without costs. TS 692, which is my suit, is decreed on contest without costs. Landlord lessors being the plaintiffs of TS 692 of 2013 to hereby get a decree of eviction of the lessee's defendants. Defendants of TS number 692 of 2013 are hereby directed to quit and vacate the suit premises within 2 months of this judgment and deliver vacant possession of the suit premises flat to the plaintiffs of TS number 692 of 2013, failing which the plaintiffs of TS number 692 of 2013 shall have the liberty to put the decree into execution.
Where is the suit property situated, Mr.
Middleton Street, Lord. 1426, 3-bedroom flat plus car parking.
Yes.
And these 3 lines is the only reference in the Lord judgment to the mean profits. There is no discussion at all before this. Perhaps, Lord, what I believe.
Come here. You have asked for adjournment. The lady behind it. Yes. Come here. You asked for adjournment. Why are you shying away? We are remanding. We are granting a plea. Here, we are telling you what has been done. Mean profits. How long have you been practicing?
Sir, 2 months.
2 months. Who is leading you?
BK Advocate BK.
Take the microphone towards you. Microphone. Yes.
The Learned Counsel Advocate BKC.
We are telling you. Mean profits means the occupation charges which are to be paid by you during the period which you are in occupation after being evicted. We are not granting a final decree on that. Trial court has granted rupees 500 per month per day as mean profits. We are setting that aside. We are saying only we are passing a preliminary decree holding that they are entitled to mean profits. We are asking the trial court itself to adjudicate what should be a calculation. And for that, you may have a hearing also. Your client will have a hearing also. And you will produce documents also, both of you. And court will adjudicate that and then pass a final decree as to the amount. So in a sense, you are also, without filing any appeal, you are also winning. Because 500, otherwise you had to pay from right now.
But till the date of the judgment, that also
Yes.
is contrary to Order 2212.
No, that also. We are setting aside the entire thing.
But in fact,
not that also.
your Lordships may also do this. Lordships may appoint a commissioner and direct not the commissioner to file the report
Mr.
before the
Shen,
trial
there
court.
have been instances we have been finding judgments High Court has appointed, then the some officer of our court, which is counterproductive to that particular advocate. He has to go and adduce evidence and all these things.
Yes.
And then there is some difficulty. There are issues. So better someone from that court be appointed by that court. It will be better. It's always better.
Lord, kindly fix the timelines, Lord, for. This is only a formality, Lord.
Judges are hard pressed. Very will put a broad.
Lord, this is a decree under BA, Order 20 Rule 12 BA. Should I be under C, directing an inquiry?
Yes, we'll just check the language of that. You're right.
Lord, kindly make it Order 20 Rule 12 C, Roman 1.
Right. Take your seats, both of you, Mr. Chen and ma'am, please take your seat.
Yes.
The present first appeal has been preferred against the portion of the impugned decree whereby mean profits were directed to be paid by the respondent stroke erstwhile lessee to the appellant stroke erstwhile lessor at the rate of rupees 500 per diem calculated from April 1, 2013 till the date of the judgment. Full stop. Next para. The short backdrop of the case is that an eviction suit was filed under the provisions of section 111 within bracket small a of the Transfer Property Act 1882 by the present appellant against the defendant stroke respondent, defendant stroke respondents. Full stop. Next para. Simultaneously, the respondents had instituted a suit for declaration that they are monthly tenants under the provisions of the West Bengal Premises Tenancy Act 1997. Full stop. Next para. Whereas the appellant's suit was decreed, granting eviction against the respondents, the respondent's suit was dismissed, both by the impugned judgment. Full stop. Over and above the above components of the judgment, the same also incorporates the decree of mean profits as indicated above. Full stop. Next para. Learned senior counsel appearing for the appellants, who are aggrieved in the present appeal only against the component of mean profits, contends that the said portion of the impugned decree is contrary to the provisions of Order 20, Rule 12, within bracket small c of the Code of Civil Procedure. Full stop. Next para. Instead of directing an inquiry as to the mean profits payable, the learned trial judge passed a decree outright, that too, for an amount less than that which was sought by the plaintiff stroke appellants, without any adjudication on the same. Full stop. Next para. Learned senior counsel further points out that whereas the mean profits have been granted till the date of the judgment only, the appropriate course of action under the contemplation of Rule 12 within bracket small c within bracket small I of Order 20 would have been to grant mean profits till the delivery of possession to the decree holder. Full stop. Next para. Learned senior counsel, in his usual fairness, submits that in the meantime, the eviction decree has been satisfied by obtaining possession in favor of the appellants in due course of law. Full stop. As such, it is contended that mean profits ought to have been granted from the date of institution of the suit till possession was recovered by the appellants.
From the date of expiry of the lease, Lord.
Sorry, from the date of expiry of the lease. Full stop. Next para. We find April 1, 2013 was the date of expiry of the lease.
Yes.
Right. We find, although an adjournment is sought on behalf of the respondents, since this is the very first item in the hearing list and has been appearing in the list for quite some time, we decline to grant such adjournment. Full stop. Next para. In any event, in view of the nature of the proposed judgment which we want to pass, further service of notice on the respondent is unnecessary. Full stop. Next para. From a bare perusal of the impugned judgment, insofar as the grant of mean profits is concerned, we find the same to be not only unreasoned, but being backed by no inquiry whatsoever to ascertain the actual mean profits which the suit property could fetch in current times. Full stop. Next para. Hence, this court is of the opinion that the learned trial judge ought to have directed an inquiry in that regard. Full stop. Also, we find substance in the second contention of the appellants to the effect that there could be no conceivable reasons as to why the appellants ought to be deprived from the mean profits from the date of passing of the judgment till the date of getting actual possession. Full stop. Next para. Accordingly, FAT 159 of 2021 is allowed on contest, thereby setting aside the impugned judgment and decree dated March 13, 2019, passed by the learned judge, 6th bench, City Civil Court at Calcutta, in title suit number 692 of 2013, comma, only to the extent that the same granted a decree for mean profits, and remanding the matter to the trial court for the purpose of the learned trial judge to undertake for the purpose of fresh adjudication on mean profits. For such purpose, comma, the learned trial judge shall take recourse to the modality prescribed in Order 20 Rule 12 within bracket small c within bracket small I of the Code of Civil Procedure, and direct an inquiry to be undertaken as to the main profits, comma, from the date of expiry of the lease, that is April 1, 2013, within bracket, from which date the occupation of the respondents became unlawful, bracket closed, till the date of delivery of actual possession by the respondents to the appellants, full stop. Next para. For such inquiry, comma, the learned trial judge shall also grant opportunity to both sides to furnish evidence, comma, if necessary. Full stop. Next para. In view of the long pendency of the matter, comma, it is expected that the entire exercise shall be concluded at the earliest, comma, preferably within 6 months from the date of communication of this judgment to the trial court. Full stop. A formal decree be drawn up accordingly. No address to cause. A formal decree be drawn up.
Would your lordship permit a suggestion from my side, Lord?
Yes.
Lord, your lordship has directed to make an inquiry. Lord, if your lordship may add, if your lordship so feel, that by appointment of an advocate commission in terms of Order 26 Rule 9.
Very well. Directing an inquiry, যেখানটা হচ্ছে inquiry কথাটা যেখানে বললাম, যেটা ordering portion এ, সেখানে by appointing an advocate commissioner under Order 26 Rule 9 of the code, it is.
Very good. Very good.
Oh, sorry. Remanded, so no decree will be done.
Okay.
My appeal.
Yes.
Appearing
for
for
the
respondents. May I?
Yes.
It's my appeal appearing from an order passed by the City Civil Court. Or
Sir, just take the microphone, please.
I'm very
Yes. City
Millard,
Civil
from
Court.
a judgment and decree passed by the City Civil Court for eviction. I appear, Millard, property is in Rafi Ahmed Kidwai Road. It's used for Millard repairing Millard harmoniums and piano and etc. Any musical gadgets Millard to be repaired. Now Millard, a suit filed in City Civil Court under the West Bengal Premise Tenancy Act. The valuation of the suit, as per Millard, the plaint case is Millard, suit is valued at rupees 4,391 and with a prayer for injunction, of course. Millard, suit filed in City Civil Court, not in Small Causes Court. Small Causes Court jurisdiction has been there, but they will, of course, argue, and I hope and trust they will argue, that Millard, there is a coupled with a prayer for permanent injunction. So, Small Causes Court cannot take. Millard, this is Millard, neither here, not there, because we are not deciding Millard, an application under Order 7, Rule 11, where Millard, partial plaint cannot be rejected. If in final hearing, if it is seen Millard, part of the decree cannot be granted, that part decree can't be granted. There's
What
an
was the
express
injunction
bar.
sought by them?
Not to sell, alienate the or Millard transfer. It's Millard arising out of the eviction proceedings in law. So it's combined with Millard the eviction. That's the first point. And Lordship will also appreciate that Millard City Civil Court Act has a Millard schedule where the specific bar, what is conferred on the Small Causes Court, City Civil Court cannot Millard enter. There's a specific bar. Similarly, corresponding with the Small Causes Court bar of injunction, that's section 19 of the Small Causes Code. There also there are two specific bar that no recovery for right to recover immovable property. That is, but by a statute, this is by given Millard under section 12 capital A of Millard the West Bengal Premise Tenancy Act 1997, where the valuations are given. And for the purpose of valuation in respect of landlord and tenant, it's Millard section 7 9 Millard 7 Millard 9 of Millard the Suit Valuation Act 12 months rent. That's first. That's the second point. The decree is only on the ground of section 2G. The Millard tenancy is 1910 plus old Millard. So Millard, I was a tenant Millard under the old regime. My father was the tenant. He died in 2010, 2009. So Millard, the judgment proceeds on the basis that 2014 my right to stay has extinguished by virtue of section 2G. And by reasons there is a decree. This is the only ground the decree has been passed. Now, Millard, there is a straight Millard judgment of the Supreme Court saying, Millard, what right I had in under the old act that cannot be extinguished by the subsequent legislation. Our two division banks said, no, it's Millard, if the tenant has died prior to the 1997 act, Millard, notification is 2001 till 2006. If it is after the act, it's Millard from the death 5 years, whichever is later. Now, Millard, this is settled by the judgment, Millard, of Justice Bench presided by Justice Sudhanshu. So that's, Millard, the only
Rajesh
point involved.
Rajesh Mitra.
Yes, that's the only point. There are no other
But
grounds.
demise occurred prior to the coming into force of this act.
Demise occurred
After the coming into force.
Even after prior, the paragraph says, Millard, it's Millard, the same thing. What is a vested right? You cannot. Because Uma Mitra who was the tenant there.
So, have you brought Rajesh Mitra? Probably that is not the law said.
Yes, I'll do that, Millard. I have done Millard. Little Millard, this is not my field, Millard. This is what I see because Uma Mitra, the tenant, who was the tenant, Millard, the widow, died in 2009 there, Millard. Same year. বলছি যা আছে আছে I cannot improve this situation. Millard, I have brought the judgment, Millard. না দেবো না তোকে দিচ্ছি এক মিনিট দাঁড়া আমি নিজে হ্যাপাজার্ড আগে 2 মিনিট দে আমাদের দুটোই কপি আছে কোনো ক্ষেত্রে And the two Calcutta view were not to be. May I, my lord, place the judgment passed or the impugned order first, my lord? Whatever way lordship wants.
Yeah, let us see the impugned.
So there
We'll
are
start
two,
with
four
that.
challenges, my lord. Kindly have a look at.
And we'll look into the provisions of the City Civil Code and the Small Cause Court Act.
Yes, yes, I am carrying, my lord, all the authorities. Kindly have a look at the judgment and decree, which is page 48 to 71 of your lord, 48 of 71 of your lordship's brief. Volume 1. And thereafter, the subsequent, my lord, rent has been taken from me after the death also, my lord. That's a third point. My lord. That's neither here nor there, my lord. So they said that they have no knowledge. My lord, if your lordship straight away come to decree page 49, if your lordship takes me. No, judgment and page 49, right? Page 49, if your lordship kindly have a look.
You can start from page 54 also if you like.
Yes, yes, absolutely.
The issues.
Yes, the issues, my lord, I will do from
Yes.
My lord, these are the issues, my lord.
Right.
My lord, kindly, my lord, takes, my lord, page 55. I just place the fact. So, my lord, it comes out, or I straight away go to the finding.
Absolutely.
It comes out, I don't have to read, my lord, what is the settled position. It is a specific case where I do it or I go to the finding. I do it, place it from here or from the finding, my lord, whatever way.
Good.
The finding.
2010, death is admitted position.
Death is admitted position.
2009, sorry.
2009, death is admitted position. Grandfather was the original tenant from 2010. Thereafter, father continued. Thereafter, I continued.
Grandfather was from
1910.
1910.
1910. Otherwise, my lord, kindly straight away come
Yes.
to, my lord, the findings, my lord, because that is better.
Yes.
My lord, or, my lord, text from, my lord, paragraph 60, page 62. Written notes from the averments in the plaint and also admission in the written statement coupled with examination of the witnesses in the suit. One fact has been clearly proved that Hemanto Pal once was inducted as a tenant of premises number 3 capital A, Rafi Ahmed Kidwairo, and after the death of Hemanto Pal, his son Tapon Pal used to carry on business in the premises accordingly. Rent receipts were issued in favor of H. Pal and Company till 39/2010. There is an admission of the plaintiff that Tapon Pal was inducted as a tenant after the demise of Hemanto Pal in the premises, but denial of the plaintiff that the defendant number 1 ever has been inducted as a tenant in the suit premises. There is no document to show that the defendant number 1, Simonto Pal, has been inducted as a tenant. One Anand Sangaria has been examined in the present suit who stated that Sikanda Pal was never inducted as a tenant in the premises, and even if it is accepted that being a legal heir of Tapon Pal, the present defendants are entitled to continue the aforesaid tenancy for a period of 5 years. That period has already been over in the year 2024, and after expiry of 5 years, one legal notice was issued to the defendant to vacate the premises within 15 days from the date of the receipt of the notice. That notice was duly accepted by the defendant number 1. The defendant number 1 did not claim that the said legal notice, which amounts to acceptance of the legal notice, and therefore in view of section 2G of the West Bengal premises, neither the defendant number 1 nor the defendant number 2 are entitled to continue possession of the godown scheduled premises at 3A Rafiq Ahmed Kidwai Road, as after expiry of 5 years, both the defendants have not been accepted as a tenant by the landlords in view of the proviso of section 2G of the Act. The defendant, more fully, defendant number 1 cannot be treated as a tenant, rather he should be treated as a trespasser whose legal entry to occupy the residential or non-residential premises, as the case may be, after statutory period, being the son of the original tenant. So this is an accepted position. I am the son of the original tenant. The proviso section 2G of the Act, there is clear mandate that the son, daughter, parent, widow of the predecessor son of the tenant who was ordinarily with the tenant in the said premises up to the death of the tenant as a member of the family and was dependent on him, and who does not own or occupy any residential premises, shall have the right of preference of tenancy in a fresh agreement in respect of the premise on the condition of payment of fair rent, and the provision shall apply mutus mutandis to the premises let out through non-residential premises. Even if, for the sake of our argument, if we hold that the present defendant is running business in premises 3 capital A Rafi Ahmed Kidwai Road since after the death of Tapon Pal, who had died in 2009. But nothing has been proved that after the death of Tapon Pal, there was a fresh agreement between the present defendant and the plaintiffs. When the plaintiffs admits that in the year 2011 they have come to know that in the year 2009 Tapon Pal died, which is also by way of an admission. The present defendant has admitted there is no dispute that Tapon Pal had died in the year 2009. Though in the instant case one, the death certificate has been filed by the defendant during the course of examination, but the same has not been proved. In view of the spirit of the Evidence Act, when the death certificate...
This part may be wrong. Death certificate could not be looked into, but it's an admitted question.
There's no dispute, Millard. Millard, kindly now, Millard, the last paragraph. Considering these aspects, I think the death certificate issued by the health officer is true. Tapon Pal died on 2009. So, judge accepts it.
Yes.
Millard, page 65. The court is of the view the defendant failed to prove that they have communicated the death of their father to the landlords in the present suit. Therefore, it is difficult for the plaintiff landlord to show the actual death of Tapon Pal, etc. Now, Millard, 2G is quoted. Millard, the entirety. Now, Millard, 67. In view of proviso to section 2G of the Act, the defendant number 1 have failed to prove their current agreement between the plaintiff. Then for continuation of the tenancy as during the course of evidence, neither they have produced any documents nor they have adduced any person who is reliable to show that even after absence of the agreement, there was an oral agreement between the parties to that effect. Though in the instant case, the plea has been taken by the defendant number 1, that by conduct of the parties tenancy is continuing since the death of their father, the plaintiff landlord have accepted rents under the head of Mrs. H. Pal and Company. That's Millard, the trading name. Pertinent to mention, though defendant has filed documents to show Kolkata Municipal Corporation for the assessment of renewal of establishment has issued, but those certificate can be treated as H. Pal and Company as a running business at premises number 3A Rafi Ahmed Kidwai Road through the defendant number 1, Srikanto Pal. Exhibit B series trade license, it has been depicted that H. Pal and Company is running through Tapon Pal, though not through the present defendant Srikanto Pal. Therefore, by no stretch of imagination, it can be said that Srikanto Pal was running the business that during the period. Those are the rent receipts, Willard, in the trading name only.
Yes.
So Srikanto Pal ex facie was not appearing there. Even for argument's sake, we hold that defendant number 1, Srikanto Pal, is running the business under this name and style of H. Pal and Company in premises 3A Rafi Ahmed Kidwai Road, Kolkata, as a tenant in the non-residential premises. But when the defendant has failed to prove that there is fresh agreement between him and the present landlord, in view of section 2G of the Act, the present defendant cannot get in relief. On the contrary, by adducing evidence and also by producing documents, the plaintiff has been able to prove that Messrs. Purushottam Lang Sangaria have issued rent receipt in favor of H. Pal and Company, in which firstly Hemanto Pal was carrying on business and thereafter Tapon, his son, was carrying on business till his demise. It has already been accepted by the court that Tapon Pal died in 2009 and the fact was not ventilated by the present defendant, and soon after getting information, when the present defendant has come to know in the year 2009 Tapon Pal died, they have sent a legal notice after expiry of 5 years from the actual death of the tenant, and the legal notice has been properly proved by the plaintiff, which have been marked as Exhibit 6, and notice has been duly served upon Srikanto Pal, Srimanto Pal. Where Srikanto Pal received the same, Srimanto Pal did not claim the said legal notice. Since the letter is not claimed by the addressee, knowing fully about the contents of the letter amounts to acknowledgement to the addressee, and that too, when denied by the addressee, cannot be treated that the addressee was out of knowledge of the contents of letter. Accordingly, both the defendants have been properly served notice. In spite of receiving the notice, both the defendants have failed to reply anything within the statutory period. The present suit has been filed for eviction from the premises. I think legal notice Exhibit 6 has been properly served on the defendant. Pertinent to mention, the defendant is not considered. As per the legal notice, defendant failed to vacate the premises. Present has been perfectly filed. Not only when the defendant failed to prove any agreement between the plaintiff landlords regarding the occupation of premises in eviction in view of section 2G of the Act, the status of the defendant, rather the defendant is a rank trespasser in respect of the suit premises, non-residential unit, and as such the defendant are bound to vacate the same in favor of the plaintiff landlords within the time frame. Here the instant case, though other arguments have been placed by the advocate on defendant in the written notes of
So you have
argument.
gone through it, more or less.
That's all, Millard. And ordered, Millard. What is the order? That's important, Millard. 71, Millard, page 71 is, Millard, a decree, Millard, of possession.
Yes.
Under the Act. And Millard, also, Millard, a permanent injunction has been passed. Millard, permanent injunction is flowing from the first prayer, Millard, which is the main prayer. That is, Millard, for possession. Now, Millard, kindly have a look at the West Bengal Premises Tenancy Act, Millard, 1997. Copy ache, sir? Copy ache.
We have.
Kindly, Millard, have a look at two sections, Millard, where the suit could have been filed. This is from City Civil Code. Kindly, Millard, have a look at section 12, capital, Millard, A.
Yes.
Special provision regarding jurisdiction of the court for trial of the suit for possession, notwithstanding anything contained. So it starts with notwithstanding. In the other law, a suit or proceedings by a landlord against a tenant in which recovery of possession of any premises to which the Act applies is claimed shall lie to the courts as set out in the Schedule 4 and no other courts. So, Millard, double negative, Millard. Notwithstanding, no other court shall be competent to entertain or try such suit or proceedings. The provision of the Civil Procedure Code, they apply to all proceedings referred in High Court except the suit or proceedings would lie to High Court at Calcutta. Now, Millard, kindly have a look at Schedule 4. So, Millard, 2, notwithstanding and no other court. Now, Millard, first, Millard, High Court is 10 lakhs. Millard, it's perhaps will be just after, Millard, the schedule, which is the end, Millard. If Lord, my book is same, it's page 73.
Now, our book also 73.
Yes,
Same.
it's where, Millard, the premises are situated on the land wholly within the ordinary original jurisdiction of the High Court at Calcutta, in case where the value of the suit exceeds 10 lakhs to the High Court at Calcutta. So, Millard, in case where the value of the suit does not exceed 10 lakhs, but exceeds 60,000 rupees, City Civil Court established under the City Civil Courts Act, such and such. Now, Millard, next. In any other suit to the Chief Judge of the Court of Small Causes, Institute Presidency Small Causes Court in town, who may try himself or may transfer the suits or the trial to other judge of the said court who shall try the suit at the court of the first instance. So, Millard, kindly now look at the valuation statement. I go by the valuation statement, Millard. Millard, page 3 of the paper book, volume 1, suit for recovery of possession valued at rupees 4391 being 12 months rent. That is as per the suit valuation act,
Yes.
Millard, which I'll, Millard, show.
Yes.
Rupees 100 tentatively for damages and 100 for permanent injunction, total 3591. That appears reiterated as paragraph 15, page 8 of the plaint. So, Millard, it's not, Millard, a mere, Millard, pecuniary jurisdiction. It's a subject matter jurisdiction by the Act. Of course, Millard, it will be argued, look, I have also a claim for injunction in the suit itself. That's page 9. That's prayer B. And also an inquiry for damages. But that is not how you have framed your suit. First, Millard, there has to be a decree saying that I am in wrongful possession. Then this inquiry can happen. So it should be the starting point of the suit. That is his valuation. Along with a decree for permanent injunction, which is flowing from, Millard, the first prayer for, Millard, eviction, which is the owner, Millard.
Eviction is the principal relief by which
principal relief. Now, Millard, it's a case of final relief. Now, so far as the final relief is concerned, whether, Millard, City Civil Court, while treating, Millard, the suit in a final adjudication, could have granted prayer. That's the reason I said, Millard, in all matters in Order 7, Rule 11, Lordship has tired of, Millard, hearing me in particular, that, Millard, partial print cannot be rejected. But it's not a case of, it's, Millard, you see a prayer, you see there is a bar, you cannot take that. Now, Millard, City Civil Court has a provision. In these cases, one has to return the plaint, Millard. That's the provision under the Act itself on the court. Now, Millard, prayer A itself cannot be granted. Now, if your Lordship kindly have a look at I go, my lord, how here? City Civil Court Act, my lord, I, my lord, just hand up. I have just one copy. I have. Ache, তোর কাছে আছে? আছে, এখানে আছে। Print out এনেছিস?
Dipankar, City Civil Court Act ছাড়া Small Causes Court Act
Court Act. Presidency Small Causes Court. This I missed out, my lord, in the morning. City Civil Court একটাই আছে। হ্যাঁ। Now kindly have a look at the City Civil Court. একটা জজ সাহেবকে একটু দিয়ে দিন না। তোর কাছে তো থাকে এগুলো সব এনডি।
You probably have the very first book in the first edition.
Is lordship only the valuation? City Civil Court একটা আগে। স্মল কজটা এটা দু কপি আছে, ওটা নিয়ে টেনশন করতে হবে। আমি এটা ভুলে গেছি সকালে।
তুমি যে বলছো তুমি সেটা বলেছি আমি জিজ্ঞেস করছি নিজের মতো।
I think law, my lord justice, justice they I know, but I think Justice Bhattacharya was also not born when this book must be, Millard. Justice they I know, Millard, 2 years here, 2 years there, Millard, must be.
Yes. So you have a copy of
City Civil Court, Millard. Just Millard, tomar print out data diye daw. I just bring a copy. I just missed out. Everything had 2 copies. I just missed it out, Millard. I also, Millard, have the old book, Millard, coming from Millard.
Dipankar, now ওরকম কায়দা করছো কেন? এরকম ভাবে শুয়ে পড়ে সোজা তাকিয়ে নাও।
ওটারই সফট কপি একটু স্যারকে দিয়ে দিন। সফট কপি একটা সফট কপি দিয়ে দিন।
Soft copy is fine. Hard device you won't be able to replace if you do something.
Millard, kindly have a look at
Yes.
the act in question, City Civil Court Act. If your lordship straight away come to the express bar of the City Civil Court, kindly have a look at first schedule. These are, Millard, section 5.4. That, Millard, I am not placing. Lordship has read it so many times. 5.4 I am not reading. Millard, kindly have a look at 17. Millard, first schedule.
Yes.
Serial number 17. Suits and proceedings, triable by small cause. So, Millard, there's a exclusive, Millard, exclusion under the Act. Exclusion under the City Civil Court Act. Exclusion, Millard, under, Millard, the West Bengal Premise Tenancy Act. Not on the subject, so, Millard, not only on the, Millard, there is a subject matter jurisdiction, Millard, restraining it. Though, Millard, now courts, Millard, I am carrying it, Hindustan Zinc and all, Millard, have put the subject matter jurisdiction and pecuniary jurisdiction together. Millard, I cannot comment, Millard, on what is the ratio for that. But that is now, Millard, has been done in Hindustan Zinc, Millard. A judgment of Justice Nariman 3 bench, they have put it in the par. But according to my understanding of the subject, one can be
subject matter and
yes, that's there, Millard.
Pecuniary.
Yes, they have put it. Is clarified subsequently by Justice Chandachud. But Millard 3 bench.
Justice Chandachud has clarified that they are on the same footing.
No, they are on a different footing. I also got, but Millard 3 bench, Millard. But here, Millard, I am saying, Millard, it's a subject.
We can follow them. If there are 2-3 benches, we can follow whatever is more suitable to them.
Yes, absolutely. Well, on a lighter note, I quote 9 there, Millard. Millard, I naturally was
9 there.
There. Now, Millard, person was arguing brilliantly, Millard. Very good. I found it to be, Millard. Then he wanted to cite some judgments, Millard. This is the mistake he did. He's saying the bench said to him, Millard, I got more nervous thereafter, Millard. I lost everything. That look, you are not confident of your argument on the law. You want to cite and refer judgments. That means you are not cited what happened in some other case. But we are not like you. We are going to dictate it right now.
No, she should have said that we are not confident of you. We're not confident that you would understand the law. Like you are doing to us right now.
The poor man got, Millard, such he could not say anything thereafter. Now, Millard, this is, Millard, bar on jurisdiction. Millard, City Civil Court has the bar itself. Now, Millard, so far as the presidency small causes court, eto du copy to, Millard, this is presidency small causes court. Judge saheb ke din ami এনেছি, এটা পাওয়া যায় না তো এটা এনেছি. If your lordship straight away take the act itself, the presidency small causes court. If your lordship straight away come to, Millard, Section 18 and Section 19. Try all suit below 18 subject to 19
Right.
of civil nature.
Right.
Now, Lordship 19 has two bars.
Hmm.
Bar A is 19D, suit for recovery of immovable property. That has been rectified by the statute. Statute makes it the forum. And Millard, suit to obtain injunction. So, Millard, can it be the intention of the legislature, Millard? Now, Millard, what if I have two reliefs? One court can grant a relief, Millard, within the framework of the suit. The other court cannot grant it within the framework of the suit. Millard, I have to, Millard, make an application or order to Rule 2 and file the second relief, which is in the forum which is appropriate to give relief. I cannot couch this prayer here and take it outside that court.
No, this suit was
City Civil Court.
Civil Court, but
City Civil Court.
as per the as per Schedule 4 of the Premises Act,
it's Millard should be small causes court. Now
Yes.
it may be argued, I'm preempting, that
That's
there is
why
a
you're-
prayer for injunction. So I have gone to Millard. This Millard cannot be an answer because then Millard, one has to go Millard, second relief, one has to pray for order to rule. So this is on the jurisdiction. Now Millard, this point has not been taken.
it was not taken in the trial.
It was not been taken. This is
That's why
taken.
you are arguing on subject matter.
Yes. Now Millard, kindly have a look at Millard, the subject matter jurisdiction. Difficulty when Lordship understands why very quickly.
But whether we understand correctly, that will be reflected in the judgment. So,
Millard,
you always run a risk there.
if Lordship asked me the
You seem
question,
to understand very quickly.
I
They're
was
supposed to
benef-
understand, quickly
I
to
got
understand.
benefited by the 2G judgments, which was presided by that other court. I got full benefit. Now, Millard, one day I saw Millard, the benefit has been reversed. Now, Millard, kindly have a look at Hindustan Zinc. Of course, it's a case. Kindly one paragraph I place, Millard.
Yes.
Millard, it follows the old Supreme Court of Kiran Singh, para 17. We are of the view that it is settled law. একটু ওকে দিয়ে দিবি হিন্দুস্তান আমি এক মিনিটে আমি পড়ে দিয়ে দিচ্ছি We are of the view that it is settled law that if there is an inherent lack of jurisdiction, the plea can be taken up at any stage and also in collateral proceedings. This was held by the court in Karan Singh versus Chaman Paswan. It is fundamental principle well established that decree passed by a court without jurisdiction is a nullity and its invalidity could be set up whenever and whenever it's sought to be enforced or relied upon or even at the stage of execution, even in collateral proceedings. A defect of jurisdiction, whether it is pecuniary territorial or whether it is in respect of subject matter, strikes the very authority of the court to pass the decree. Such a defect cannot be cured even by consent of the parties. If the question now under
The correct proposition. This
Yes.
is the proposition which
but
you know.
whether pecuniary jurisdiction can be waived,
Oh, whether it is pecuniary.
can be. But Supreme Court, Millard, I find the 4-bench judgment. Now, what is the
No, half a second, miss. Defect of jurisdiction, whether it is pecuniary or territorial. Oh, yes.
This is a 4-bench. It follows a 4-bench. Subject to, well, I'll check it up again. It's a 4-bench. I do not know, Millard, how 4-bench judges can form a.
Whether it is pecuniary. Are you reading it correctly? Or?
Millard, that's Millard the quotation, Millard, of the judgment. I have checked up from the hard copy of the book also. But here is subject matter is neither here nor there. And Millard, it's more worse because Lordship will see in an arbitration.
What happens to the sections 16 to 20 of civil procedure?
Millard, it's an arbitration where you participate, the
Yes.
jurisdiction point
Yes,
is
yes,
waived.
right.
Section
Right.
16.
Yes.
You, Millard,
yes.
participate, Millard, waived, you file a 16-2 up in appeal.
Yes, it's
But if you
dangerous.
participate, exchange, it's a case in arbitration. And it's taken up for the first time in the Supreme Court. And the award is set aside on subject matter jurisdiction.
Yes.
Participation now, Millard, is nothing. Win in arbitration after this judgment. You file a section 16, you
Where is
don't-
the clarification?
clarification I'm giving, Millard. I'll just skip Millard.
Clarification is not important in your case, actually.
Not needed, but I'll give it, my lord. That is clarified.
This is wider than what you are arguing,
Yes.
but we are not bothered
Yes.
with pecuniary.
Now, my lord, now, my lord, let us go back, my lord, to the base.
Clarification, give it to Mr. Karmakar, it will be more appropriate if he cites.
Yes, I'll definitely.
Yes, even if you hold, because as per this, even if you say it is pecuniary, then also
Gone. My lord, 3 versus 3, my lord. So, kindly have a look at the judgment, my lord, in 2G case, my lord. Justice Sudhanshu. This is 2024 SCC Online, Supreme Court 2607. তোমার কাছে থাকবেই এটা এটা তোমার ওর কাছে থাকবে না কার কাছে থাকবে yes kindly have a look at Millard straight away come to Millard page 2 paragraph 3 running to page number Millard internal page 2 the cross examination initial tenant was Mr. Usha Mitra's husband who died in 1970. Usha Mitra continued as a tenant by acceptance. She dies in 2000, 3rd November 2009, like our factual scenario. He dies in 2009. So Usha Mitra is the tenant who died. Because this is the question Lordship will ask me now. Kindly take the definition of tenant is paragraph 4. Tenant means
yes,
by whom or whose account on behalf of rent a price let out for special contract would be payable includes any person continuing possession after termination of tenancy or in the event of such person's death of such person's heirs that were ordinarily residing with him at the time of death but shall not include any person against whom a decree or order of eviction has been made by a court of competent jurisdiction. So Millard, this is Millard. One has to be a legal heir. Of a tenant to continue, this was the protection given to the tenant under the 56 Act, Millard. So Millard, since the tenancy is an old tenancy of 1910, and Millard, it is continuing, whether the Millard from Millard grandfather flowing to father, the grandson will get it or not, irrespective of the death after the commencement of the Act. That's the reason I showed Millard the cross-examination part in paragraph 3, because Lordship will find the paragraph before. Original tenant is Mrs. Mitro's Millard husband who died in 1970. Mrs. Mitro thereafter continued as a tenant. It's not a case Millard testing Millard, the Millard between Millard, the original tenant and his sons Millard. Original tenant, his widow, his son. So Millard, widow become a tenant. So Millard, without that protection can be given to, because Millard naturally, Millard son, daughter, widow, mother. Millard mother is there. So Millard, whether the son gets it or not. Now Millard kindly takes the next line. In the other words, I'll just place it in bit detail because Lordship will be in the other words, in the event of death of the tenant, the tenancy devolved on the legal heirs of the tenant who ordinarily resided with him. In the case in hand, therefore, the tenancy devolved upon S.K. Mitra's widow and the appellant who were with children aged 2 and 5 at the time of his death. That's 1970. Subsequently, the new Act came into force with effect from 10/7/2001, and the tenancy would devolve upon the legal heirs of the tenant as specified in the 2G, but for a limited period of 5 years. The spouse of the tenant, though, is excluded from the time limit provided she meets the criteria. Section 2G reads as under. Now, Lordship will section 2G is quoted. Now, kindly take paragraph 5. The landlord's case is that the death of S.K. Mitra in 1970, his wife Usha Mitra became the tenant as per section 2H of the Act. There is also mention that she gave an undertaking to the landlord that only she succeeds on the property as a tenant, and it was her who continued to pay rent after the death of her husband. So she became a direct tenant. When Usha Mitra died in 2009, the appellant would be considered tenant only till 3/11/2014. This is the factual scenario of the judgment. 5 years after the date of Usha Mitra on 3/11/2009 as per section 2G of the 1997 Act. As we have already referred earlier, the main thrust of the landlord case was that the appellant defendant has admitted in his deposition in a different manner that his mother was a tenant on the property who passed away in 2009. Here the tenancy has expired long back in 2014 as per his own admission. Now kindly take Millard paragraph 6. The learned single judge did not accept. Now Millard kindly take the legal question. Millard single judge, the paragraph 6, Millard, I am just undisputedly, Usha Mitra become a tenant under section 2H of the 1956 Act. However, when the facts were considered along with the deposition of appellant number 1, it was held that the learned single judge of the High Court that after death of Usha Mitra in 2009, the appellant would be a tenant under section 2G of 1997 Act only for a period of 5 years, which would be calculated from the date of Usha Mitra's date due to the words whichever is later appearing in the sections 2G. 5 years got completed on 2/11/2014, after which the appellant got no right to remain in the premises. As we have already stated above, the learned single judge was not correct in decreeing the suit on the so-called admission. Looking at the facts of the case and the position of the law, it was not proper for the court to give a judgment on admission simply because there cannot be any admission against law. In any case, it is not unambiguous admission as made out. In view of the discussion, the legal question to be determined by us whether the appellant has become a tenant upon the death of the father by virtue of section 2H of the old act. Further, what would be the enforcement of the new act on the years of the tenancy? Now, Lordship will kindly take Millard. The division bench is quoted, Millard. Now, Lordship will straight away omit the division bench. There is, Millard, on the top, page 7. Millard, the single judge's view of the High Court, which is in effect being affirmed, Millard.
Yes.
Miss such and such, who relies on the decision of the single judge of the High Court at Calcutta in Gautam De versus Jyotsna Chatterjee. In the case cited, the original tenant had died prior to the enforcement of the 1997 Act. He was survived by a daughter and her husband. Gautam De, subsequent daughter of the original tenant, also died in 2011, after which the respondent landlord filed a suit for eviction against Gautam, which was decreed. By virtue of section 2H of the Act, it was held that the vested right had acquired in favor of the daughter of the original tenant, which could not be abrogated by the enactment of 1997. It was further held that section 2G of the Act of 1997 interpreted literally would mean that all inherited tenancy in the 1956 would expire on 2006, the 5 years after coming into force of 1997. This is the position which cannot be tenable in law. According to the learned judge, the above case, it was held a phrase from the date of coming into force of the act, whichever later, which was wrongly drafted by the legislature and it is read redundant. So what, and this was what said. Now, Millard, it is the quotation of the learned single judge. Millard, next, relying upon, Millard, page number 8.
Yes.
Relying upon the above judgment of Calcutta High Court, the counsel for the appellant would submit the similar tenancy in the present case has in fact devolved upon the present tenant way back in 2070 on the death of the father who was the original tenant. This could not be undone by applying the provisions of 1997 Act by a subsequent legislation. In the other words, in 1970 tenancy was heritable, thus was the appellant along with her mother has become the tenancy. This is Millard, Lordship was saying Millard. Now Millard, Lordship takes the next portion, it takes Millard a something Millard a different. I'll Millard show that. This is what Lordship was saying. Now Lordship will kindly take Millard, page number 10, Millard, para 24, bottom.
Yes.
Thus, the counsel for the respondent landlord would argue that even if the appellant's claim of tenancy in 1956 and also their tenancy would expire on 2006, 5 years later of the act, the logic is based on interpretation of term whichever is later. In the other one, protection for 5 years, even for one who had inherited the tenancy under the old act was in force, that is 5 years from the death of the tenant, enforcement whichever is later. Since the new act came into force in 2001, therefore, although the tenant, as the case be the father of the appellant of the original tenant, died in 1975, but 5 years counted from 2001. In the other words, the language suggests that the purpose of covered the date of the tenant which occurred during the subsistency, but the interpretation would depend on the respective year. This is what fell from your Lordship, Millard. Now, Millard, question 10 is, Millard, paragraph 10 is the question. Whether the 1997 Act would cover the situation tenants who were protected under 1956 in this situation. So my father was a protected tenant, Millard,
Yes.
as per the definition of Millard, the section of the 1956 Act, Millard, and whatever his heirs, Millard, I get it. Now, Millard, kindly, Millard, the High Court had held that legislature, by virtue of Section 2G of the Act, intended to extinguish all tenancy of all legal heirs who has inherited on the date of the predecessor before the commencement of the 1997. Such right would expire after period of 5 years of the commencement of the Act. Now, Lordship will straight away come to Millard, para 12. The entire issue resolving around interpretation of the phase for a period not exceeding 5 years from the death of such tenant and from the date of coming into force of the Act, whichever is later, used in Section 2G. There is no ambiguity in the case of original tenant passes away after the commencement of the Act. It is clear the specified heirs will get limited protection for 5 years. The difficulty in enforcing the above proposition 12G in a situation where the order died before the commencement of the Act prior to the July such and such. This is, beloved, the distinction drawn. The learned single judge observed that a literal reading from the date of coming in whichever is later would read absurd that all tenancy devolved in 1956 Act would get altogether on the same day in 2006, 5 years from the commencement of the Act, as the single judge held the aforesaid redundant and a piece of loose legislation. Now, Lordship will kindly now straight away come to para 16.
Yes.
The current position of law, as it seems to be a decision of the Calcutta High Court, is that 1997 Act represent a shift for the legislative intent, while 1956 Act approached a tenancy as heritable right that can be claimed by a legal heir of the original tenant. This position was changed by 1997 Act to provide limited protection for 5 years to specified heirs or tenant as per the High Court in case originally died during the existence of the old Act, and 5 years to be counted from the commencement of the Act. This was our view. In our considered opinion, the view of Calcutta High Court cannot be sustained. The High Court in Gautam Supra held that the new statute touches upon the existing rights cannot be retrospective without an express provision. Necessary implication, the clear intent of the legislature Gautam they relied upon by Section 8C of the West Bengal of the General Clauses Act, that new statute does not affect the rights. Section 45 of the Act repealed 1956 Act, but cannot mean the right accrued under the old Act are extinguished altogether with the enforcement of the new Act. Now, Millard, this is Vatika Township is quoted of the various rules. Millard, retrospect, it cannot have any retrospective operation. Lordship will straight away come. Keeping in mind, para 18, to be kept in mind that the courts must differ from the literal meaning of the word. If the word any provision provides absurd result, there are specific grounds which a landlord can seek eviction of a tenant. These are the provisions are well immediate recovery for the position of landlord, but Section 2G of the Act cannot be interpreted in the manner done such and such. We are of the view on and from the date coming in force of the Act, whichever used in Section 2G was rightly held to be superfluous. Gautam Day, we do not have no wisdom of the legislature, etc., etc. And whether the decree was set aside. Para 21 and 22, Miller.
21, please, once, please.
Yes. It is true that the legislature cannot restrict
Can
restrict heritability of an amending or a repealing law as the case may be. The division bench finding that the impugned judgment dated such and such, that since the legislature can restrict heritability, it has done precisely in 1997 Act by adding the word 5 years from the date of the tenant or from coming of the for whichever is later. Hence, as per the division bench of the High Court, the death of S.K. Mitra also stand covered by the new Act. Covered by the new Act. In the other words, 90 cents heritable right retrospectively to the division bench, although the actual date of eviction would happen in a post-new Act, but does not have a retrospective operation as much as applicable to the case. So this is what has been held. Now, Millard, kindly also have a look. Kindly, Millard, also have a look on the factual. So this is the judgment in question. Also have a look. 2, Millard, document there. Volume 2, if your lordship kindly. These are rent receipt. Page 187 of your lordship takes, Millard. These are, Millard, 186. These are the rent receipt after the death of the tenant, Millard. They say they have no knowledge of that. Kindly. 183 onwards. Millard, 183 onwards, these are, my lord, 188, these are all post. He says that he had no knowledge that the business has been run by me, but I have gone on paying the rent. H. Paul and Company. The plain case, it's a case by the proprietorship. The plain case is a proprietorship concern. So after the death of the father, it comes to the son. It's a proprietorship. That's the plain case. If your lordship takes the paragraph of the plain, it's a plain case. So 183 onwards, these are all, my lord, acceptance of rent, my lord, after death.
Mr. It will be over soon. He's finished almost.
I almost finished.
Yes.
So, my lord, these are, my lord, acceptance of rent by the proprietorship. It's a proprietorship concern. So, my lord, this is, my lord, the subject matter in question, my lord. There are twofold, threefold submission. A, my lord, acceptance of rent factually, which the learned judge, my lord, said, my lord, of the that, my lord, there is, how could he have had a knowledge that the proprietor died or not? I have accepted the rent without knowledge. So that is not continuation of tenancy. Second part is, my lord, heritable tenancy, my lord, 1910, though the death is subsequent, my lord, whether I'll get the protection or not, because it's 1910 tenancy, that's admitted, my lord. Next, my lord, the next, my lord, question, my lord, is, my lord, the jurisdiction of, my lord, city civil court to pass the decree.
Yes.
These are, my lord, my three, my lord.
Yes.
The 3 points have been argued before your lordship. First is jurisdiction. Second is with respect to, my lord, acceptance of the rent. So, my lord, fresh creation of tenancy. And the third, my lord, is with respect to 2G does not apply because of the protection from the old act. Now, to start with, my lord,
one is city civil code, small cause code bar. The second is the Rajesh Mitra's case, retrospective, no retrospective. And third is this subsequent rent receipt.
Lord, I shall deal with, Lord, may I deal with, Lord, first Rajesh Mitra, indicating, Lord, that his case does not come within that parameter at all. Lord, kindly comes to the judgment cited by my senior friend, Lord. I'll take your lordship to paragraph number 4 straight away. Although my learned senior friend has placed, we will have to go briefly on the facts of the case in order to have a perspective of what we have before us. The premises was originally let out by one S.K. Mitra. Subsequent to his death, 1970, as per 2H, the tenancy devolved upon the legal heirs. Number definition given. In other words, in the event of the death of a tenant, such and such, the tenancy devolved on SK.
Mark that, Mr. Kormakar, probably your argument is that here the appellants
the tenancy had devolved at that point of time.
On them as well as Usha.
Yes. Today,
simultaneously.
Yes. Today, what is here the case? His father was a tenant. Admittedly, there is no difficulty. He got that benefit when his father died.
These people were not co-tenants with his father at any point of time, unlike Usha Mitra and appellants.
So, Lord, this does not apply at all. Second, Lord, on the death of Lord, this particular our tenant today, Lord, that is Topon Pal, Lord, for 5 years protection he was entitled to under 2G. Yes. So, Lord, till 2014, Lord, whether I was admitting him as a tenant or not, the statute recognized him as a tenant, them as a tenant, because they were ordinarily carrying on their business.
Yes.
So, Lord, because they were ordinarily carrying on their business in the sole proprietorship form.
During that period, under 2G even they were...
Yes, they were entitled. So, Lord, my case is, after 2014, they become a trespasser.
Those rent receipts are before 2014?
Yes, till 2010. Lord, I shall take your lordship straight away to the rent receipts. Kindly, Lord, comes to...
So, that was during the 2G moratorium?
Yes. Lord, kindly comes to the rent receipts once.
Is 183 onwards?
Page 156, second volume.
No, 183 onwards, please.
183.
156, 183 onwards.
Acha, post date.
Post, yes. Post. We are interested only in the post.
183. Lord, kindly comes to 186. The last of the rent receipt, your lordship would find, my lord, at page 188. That's on 30th of September. 30th of September 2010. Because my case is that I did not know about his death. Immediately I came to learn about the death. I stopped accepting this. And my lord, thereafter, what they did kindly comes to page 191. So my lord, they go and file before the rent control. So immediately upon knowledge, I do not recognize them as a tenant, but under the law they are tenants, cannot be helped. So till 2014, they enjoy that right. After 2015, they become trespasser. So my lord, Rajesh Mitro is on a completely different footing altogether. Could have been a situation if Topon Pal, along with these two were brothers.
Like Usha.
Yes, were brothers. Things would have been completely different.
Understood.
So, my lord, that is my answer to that 2G.
City code.
Yes. Now, my lord, city code. My lord, kindly comes to the small causes code, my lord, section 19. Presidency Small Causes Court Act, my lord, 1882, page section 90.
Yes.
Suits in which court has no jurisdiction. Suit in which court has no jurisdiction kindly comes to D. Suits for recovery of immovable property. So Presidency Small Causes Court specifically does not have jurisdiction in case of a suit against a trespasser. Lord, section 12A read with schedule 4 applies in a situation where this act applies. Protection under this act, section 6 parameters, or my lord, a tenant is coming to enforce some declaration, or my lord, the obligation of a landlord, or anything of that sort. That's why my lord, schedule 4 is important. Schedule 4 does not, my lord, take away, my lord, the right of the, or my lord, the entitlement of the court to sit on.
Schedule 4 applies only to eviction of tenants under this.
One, and also, my lord, schedule 4 also applies. That's why, my lord, A and B is there. Also applies to, my lord, suits for declaration and injunction, where, my lord, the landlord is violating some condition under this, my lord, statute, and the tenant wants to enforce that under the statute. So, my lord, there also, my lord, this applies. So that's why not only C, A and B has also been provided. That's the purpose of, my lord, schedule 4. And this amendment was introduced in 2009. Your lordship recalls much better than me, my lord, that alpha, beta, gamma case.
Yes.
That confusion arose, and that's why this amendment was made.
Demanding everything right now.
Everybody was running everywhere, not to know where to find what.
Throughout the Greek alphabets.
Now, my lord, that's the purpose of schedule 4. So, my lord, subject matter jurisdiction, pecuniary jurisdiction, in my respectful submission, my lord, is not germane at this stage. Because in my plaint, kindly, my lord, comes to paragraph number 13, page 7. My specific case, since defendants are continuing in wrongful occupation of the suit premises as trespassers thereof, they are not entitled to transfer. And that's the case made out for injunction. My specific case is that they are trespasser. Section 2G does not operate, my lord, under the parameters of this act. That's why Section 7 protection or adjudication is not available in a suit for Section 2G.
Obviously, yes.
This is only under the operation of law.
Nothing applies. 6 also does not apply. 6 also does not apply. Section 6 also does.
Absolutely.
Nothing is required.
Absolutely. So, my lord, this is not a proceeding under this act. It is because of the operation that umbrella goes, and that's why he becomes a trespasser. And, my lord, under section 19D, your lordship has seen, my lord.
And language of 12 capital A, one is that landlord against a tenant. That is the language.
Right. So, my lord, there is neither a contractual tenancy, there is neither a statutory protection, nothing is there. The privity of landlord and tenancy, my lord, goes. So, my lord, neither section 12A applies, nor the schedule. So, my lord, the subject matter jurisdiction or pecuniary jurisdiction, everything takes a backseat. No, that's my answer to my learned friend's argument on blood. And with the proposition of Hindustan Zinc, there is no quarrel, but only I do not know whether that pecuniary and subject matter jurisdiction, not a stage to discuss on that. Lord, these are two, and Lord, mere acceptance of rent, Lord, is not a creation of tenancy at all. That for that, Lord, may I?
This is only the change judgment or subsequent?
Subsequent judgment. No, that judgment is there, 93 CWN, but Lord, I'll not cite that. I have that, Lord, although.
Whatever, you can cite the last.
Lord, I'll just. This is an unreported judgment. Division bench, Lord. Not here also that 2G, the issue was 2G, and Lord, that rent was accepted about after that Lord, the expiry of the tenure death. Lord, kindly comes to page number 6.
Yes.
It is clear from the definition that sons not ordinarily living with the original tenant at the time. My lord has kindly got it, Lord.
Yes, yes.
At the time of death and not dependent on him are not entitled to protection 5 years. In the instant matter, the widow was extended the protection till her demise, and she was living with the original tenant solely dependent on her with no alternative accommodation such as. The evidence of the defendants clearly established that they do not come within the purview of 5 years benefit as they were such and such. It's right law that mere acceptance of rent after the expiry of the period of tenancy without anything more does not automatically create a fresh tenancy. No, this is a settled proposition. I need not, Lord. It's only for the sake of my learned friend argued, Lord. Learned senior friend argued, Lord. That's why I have to cite this. But it's a settled law. Lord, here I was, and I have a better case. Here, Lord, I was not aware of the death. I accepted rent only till 2010. I have indicated. Thereafter, I refused. They have went on to go to rent controller and then started depositing. Lord, again, depositing rent controller does not create anything. Lord, does not create a tenancy. And Lord, moreover, filing of this suit and not recognizing them at any point of time as a tenant, Lord, takes away, Lord, that argument that I have tendered rent and he has accepted. আর কিছু দেখানো বাকি আছে? না, 2G's জন্য আর দরকার নেই. Lord, here the specific case was, Lord, he said that particular sole proprietorship firm was in since 1910, tenancy was there. It was continued by his grandfather. His grandfather died sometime in 1970. Thereafter, his father continued, and 2009 his father died. This is an admitted position. There is no quarrel on this. So, Lord, till his father, he enjoyed the benefit of 2H under the 56 Act. After Lord, his father, Lord, 2G, 5 years, 2014, he goes out of Lord the premises.
So Hemanto became tenant in 1910.
Hemanto became tenant in 1910. Thereafter, Tapon Pal was there.
Tapon died in 2009.
Tapon died in 2009. The appellants, Lord, before your lordship are heirs of Tapon.
Yes.
So this is not the my submission, respectful submission.
Yes, Mr. Ghosh, you want to add?
His case is there's a trespasser suit, my lord, so the provision of the act will not apply, my lord. So, my lord, he has gone to, my lord, city civil court, filed a trespasser suit. Now, my lord, do I become a trespasser, my lord, on, my lord, automatic, my lord, the expiry of 6 years or 9, that lordship has to, my lord, hear me on that, my lord. I can do that 10 minutes after lordship comes back, or can do it now, my lord, whatever way lordship says. That's the main thing, my lord. I have to, my lord, address that.
We'll continue with this after recess.
Because after I get that status, legal protection, I automatically become trespasser.
Lord, only one request, Lord, if I do not have a reply, although, Lord, he is in reply. Lord, I am sure, Lord, he will not be on facts. But Lord, if Lord,
legal, it is legal.
reply.
No.
Lord, if I am called for, my lord, then if I am required, my lord, then kindly excuse me, my lord.
Then tell us where to go. Sure. Lord, if
Lord,
we will ensure that you are not called for, because you don't have a further right of hearing. Your Lord, Junior will be here. He'll be here if
I
necessary. On
only have
facts,
to answer, my lord, whether I become a trespasser.
it's a
That's
question
all.
only answers on the law.
Yeah, only law, my lord. That's all and only this.
You
Judge.
got it after recess and
Yes, yes, absolutely. I'll continue. সিভিল কোডের কত jurisdiction, pecuniary jurisdiction.
Item number 11 will continue.
Yes, Millard, only one thing, Millard, I have found out, Millard, this issue. Millard, kindly, Millard, permits me, Millard, to show Millard from Millard the iPad, Millard, the what will be the legal status in a context of 2G after expiry of 5 years.
What is this?
Millard, is a judgment of this court, Millard, of justice standard, of course, singly sitting in a second appeal, Millard. Lordship permits me to cite that from here because I got ready in the recess. I got it from the server.
New judgment because after
Because Millard, I have to answer my status. Millard, this is Millard not framed as a trespasser suit. Now, as an argument,
very well, you decide.
This is the I know Millard Lordship's view, Millard. Millard, first of all, if your Lordship takes the plain Millard, Millard, a trespasser is a person, Millard, whose initial entry is wrongful. This is Millard covered by 2 judgments of the court, Millard, because now its case has been said it's a trespasser suit, not a suit filed under the West Bengal Premises Act. Because the valuation statement is the 12 months rent. Now, if you take my 12 months rent, naturally, Millard, it's a case of Millard. Otherwise, the trespasser suit, Millard, has to be valued, Millard, differently, Millard. It's a 12 months rent. That's the plaint, Millard Lordship has seen it. On my rent, it has been framed. Now, Millard, if my entry, Millard, is not lawful, but Millard, I was entitled to remain in the premises by virtue of either an agreement or Millard by virtue of an act, Millard. Subsequently, that protection being going away, Millard, Millard, I become a trespasser, or Millard, Millard, continue Millard like Millard 116 holding over, tenant at sufferance or some other, and which provision of the act will be pressed into operation of against me. Now, Millard, there is a Millard division bank judgment, Millard, of this High Court, Nili Maria Jute Mill, in case of a lease. There, Millard, 116 was Millard contested, Millard, on the provision, and says, Millard, yes, the status is not that of a trespasser, because your initial entry was not unlawful.
Tenant at sufferance.
Tenant at sufferance, or Millard, it's something else now under which provision you have to sue me. Because Millard, my protection is under Millard section 2G. The section 2G is a protection under the act. Now, eviction will be under the act after the provision goes, or it has to be something treating me as a rank trespasser. That is the only issue, Millard, today Lordship has to decide.
So, what will be the status of the person after
severance, Millard, of Millard that 5 years period? Millard, it is not a tenant at sufferance, not a rank trespasser. That is the Supreme Court. I checked up. I know I am in a reply because the suit was framed as if it's a suit under the Millard West Bengal Premises Act on the 12 months rent. The valuation is on such basis. Court fee has been given. Now, today's argument has been made. It's not a Millard suit under the Premises Act. It's a suit, Millard, against a Millard rank trespasser, Millard. Hence, Millard, kindly have a look, Millard. This view of our division bench was, Millard, found, Millard, even by the Millard, even by the Supreme Court, Millard. If the initial entry is lawful, subsequently by operation of law it becomes unlawful, I don't become a trespasser in law. Millard, this is Millard 2000. Tenant at sufferance until a degree. Yes. This is Millard the language, as rightly Millard said. Millard, kindly Millard have a look at 2000 volume 2 Calcutta Law Journal, page 70. Yes. Enough. Millard, this is Millard, found Millard, even Millard by the Supreme Court. Millard, kindly have a look at paragraph.
Yes.
7. Millard, internal page Millard 2. Citation page na bole dijo, kar se di dijiye.
Yes.
Millard, it has been stated that the suit has been valued on the basis of market value of the property, section 4A of the West Bengal Court Fees Act. Now, 8. Under the Court Fees Act, Court Fees Act law under the West Bengal court suit has to be valued in terms of the provision thereof. A suit for recovery of immovable property from a tenant, including a tenant holding over after determination of the tenancy for eviction, would still be a suit between the landlord and a tenant and not between a owner and a rank trespasser. Next, it may be noted even after the Court Fees Act of 1970, the suit for recovery of immovable property tenant, including the tenant holding over after determination of tenancy, is governed by Section 79C of the Act. Now, Millard, Section 10 with 116 is quoted, Millard. Now, kindly, Millard, takes 11. There's a distinction between a tenant continuing possession after determination of lease without the consent of the landlord and a tenant doing so by the consent of the landlord, where the former he is called the tenant at sufferance and the latter he is called tenant by holding over. This lordship said, Millard. The valuation of the suit was therefore required to be done as if done between the landlord and a tenant. So far as the suit between the landlord and the tenant is concerned, the mean profit, if any, is to be complete up to the valuation of the institute of suit and not on the basis of hypothesis in terms of such and such. Now, lordship will kindly straight away come to paragraph, Millard, paragraph 18, 1818. It is true that for the purpose of valuation of a suit for determination of the court fees payable, thereon the averments meant and the relief sought in the plain determines the character of the suit. The clause 5A of Section 7 of the West Bengal Court Fees Act cannot thus be said to be applicable in the case where the same is applicable, where the suit is filed against a defendant who was a trespasser from the very beginning. The word trespasser has a variable meaning which is used in different contexts and different statutes. So far as the West Bengal Court Fees is concerned, the word trespasser must mean a trespasser from the very beginning and not a trespasser who had original title but lost the title by efflux of time by reasons of an agreement between the parties. It should not be off, it should be or by operation of law. So I have lost a title by operation of law. How a trespasser suit will lie? This is, Millard, upheld by the Supreme Court, Millard. Millard, in 2004-13 Supreme Court cases 448. Millard, kindly have a look at, Millard. This went from this court, Millard. Kindly, Millard, have a look at the judgment in question. Millard, straight away, Millard. Others are, Millard, 11 and 12. That's all, Millard. On the principle of law on this judgment is concerned. The division bench in this court, a division bench in the context of the Court Fees Act and the pecuniary jurisdiction came to the conclusion that the suit of landlord ought to have been valued under Section 7(3)(d) of the Court Fees Act, as the recovery of immovable property includes a tenant holding over after determination of the tenancy. The division bench further held that the trespasser means the held under the Court Fees Act, the trespasser means a person who has been one from the very beginning and not one who had original title but lost the same by efflux of time or by operation of law. We do not find any infirmity of the division bench order passed by the division. It should be judgment has been given by the in context of the Court Fees Act on pecuniary jurisdiction of the court to try cases. In this circle, we are not inclined to interfere. So, like, this is the case, Millard. Where is the case of against a rank trespasser? Because my entry is not unlawful, and the trial court proceeds on the basis I am a trespasser. भेजो दिए दाओ एक बार हाँ Lordship will also consider Lordship will also sir eta apnake পাঠাচ্ছি জলসে will also consider the second appeal case SAT 27 of 2023 Millard, where Millard this point has been dealt with, Millard.
It is no longer res intriga দিয়ে শুরু হচ্ছে প্যারাটা
It is no longer res intriga the para starts. I am very sorry, Millard. Eta
what is the number SCT
27 of 2023
কোথায় দেখা
7 of 2023
দেখা বার
27 of 2023 date of the judgment
28 August 2023
দিয়ে দাও জজ সাহেবকে দিয়ে দাও
24
23 28 August 2023
জজ সাহেবকে দিয়ে দাও জায়গাটা বার করে দাও So, the suit as framed, it is by 12 months rent, that is under the act. Now, I enjoy 2G. All of a sudden can't be a trespasser. You have to take recourse under the act, say, my right to remain in possession has gone and throw me out. So of course, a single bench, but division.
Admission.
Oh, admission.
This will be scientific admission. যেখান থেকে লিখতে হবে তোমার এখানে দিয়ে দেবো একবারে খুলতে হবে
দে একবার
একবারে এয়ারড্রপ এয়ারড্রপ
How is this relevant?
This is I kindly look at them.
Section 6 suit file হয়েছে
Section 6 suit was filed very well, আমি দেখিনি এটা kindly look
Read it out, you'll understand why you are saying.
Absolutely. আচ্ছা ঠিক আছে জজ সাহেব
No, convince us, Mr. Ghosh. We are open to arguments.
It's that's everyday lordship is open to
How is this judgment relevant?
Even in a 2G case.
I'm sorry, it's peripheral.
Comes within peripheral.
Yes. He says, even it's a 2G case, you have to file a suit under section 6.
See the next subparagraph?
Subparagraph.
Find any feature on the land of which.
That was at that point of time when he was tenant. That's very
well. Kindly takes Nili Maria. The status has been explained in Nili Maria. So the trespassers to today. If I am getting a protection under the act, am I not to be sued in the forum which gives the, because I do not immediately become a trespasser by operation of law. So these are my respectful submission on the trespasser suit will not lie. And even where he is going to file this suit, because lordship knows the city civil court jurisdiction is upwards than the valuation in the suit. How can he file it in city civil court? 3,000, 4,500 rupees.
Hindustan Zinc was cited.
I cited it on the count of jurisdiction, Miller.
Right.
And Miller, so far his judgment is concerned. Kindly have a look at Miller, paragraph 6, page 6, Miller, page 6. Full boleche. Huh? Miller, page 6, bottom, Miller.
Yes.
It is trite law that mere acceptance of rent after expiry of the period of tenancy without anything more do not automatically create a fresh tenancy. It is true that assent of the lessor may be inferred from acceptance of rent, but what is relevant if such acceptance was made to create a fresh tenancy? Now, Miller, there is here the proprietorship form has a name. It's giving the name. It's the father died, here goes on acceptance rent. This is the something more here, That's the reason I gave the rent receipt. And there is no discussion. And there is no discussion on that. So it's an agreement which has come into force. That's my third limb of my argument. So far as trespasser suit is concerned, I cannot be a trespasser. It cannot be a trespasser suit because my initial entry is not unlawful. If I am protected by operation of law in a lease, it's operation by a contract. Here it's by operation of law I am remaining in possession. Immediately on the first day after 5 years, I cannot be a trespasser. I may have lost a title by operation of law. That does not mean I become a trespasser because my initial entry is lawful. And if your lordship also, have a look, paragraph 3, rent receipts were not given, That's factually, Neither here, not factually. I have the rent receipt, full proof, they have accepted till 2010, Of course, during the monitoring. These are my respectful submission.
The present appeal has been preferred by the defendant in a suit for eviction on the ground that of operation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. For sub next para, the brief facts of the case are that originally the grandfather of the present appellant, comma, one Hemanto, was inducted in the suit premises in the year 1910 as a lessee. Full stop. Subsequently, comma, on the demise of Hemanto, comma, Topon, comma, the father of the appellant, comma, inherited such tenancy. Full stop. Next para. On the demise of Topon, comma, the present appellant, comma, as his son, became a tenant in respect of the subject proper of the suit property. For the next para, it may be noted that the rent receipts in respect of the said tenancy were all along issued in the name of the sole proprietorship of the successive tenants. Full stop. Next para. The present appeal, the present challenge has been preferred primarily on three grounds as enumerated below. 1, Roman 1, the City Civil Court did not have subject matter jurisdiction to entertain or decide the suit. Roman 2, that the operation of Section 2 within bracket small g of the 1997 Act is not retrospective and, comma, as such, comma, could not affect the accrued tenancy rights in respect of the suit property in favor of the predecessors of the appellant, comma, through whom the appellant claims tenancy. Roman 3, in view of the issuance of rent receipts by the respondents in favor of the appellant, even subsequent to the demise of Topon, comma, the father of the appellant, comma, it ought to have been construed that the appellant has been independently recognized as a tenant in respect of the suit property. Next para, we proceed to adjudicate the appeal issue wise. তারপর নিচে একটা ইস্যুটা হাইলাইট করে কি ইস্যু 1টা আমি যেরকম বলছি, whether the city civil court had subject matter jurisdiction to entertain and decide the suit. তার আন্ডারে learned senior counsel appearing for the appellant places reliance on section 12 capital A of the West Bengal Premises Tenancy Act, in terms of which, comma, notwithstanding anything contained in any other law, comma, a suit or proceeding by a landlord against a tenant in which recovery of possession of any premises to which the 1997 Act applies is claimed shall lie to the courts, comma, as set out in Schedule S capital Roman 4, and no other court shall be competent to entertain and try such suit or proceeding. Push up next para. Conjointly with section 12 capital A, comma, learned senior counsel places Schedule capital Roman 4, which stipulates that where the premises are situated on land wholly within the ordinary original civil jurisdiction of the High Court at Calcutta, comma, in case the value of the suit exceeds 10 lakh rupees, comma, the suit would lie under clause small a within bracket of Schedule IV to this court, comma, whereas in case the value of the suit does not exceed 10 lakh rupees but exceeds 60,000 rupees, comma, the City Civil Court established under Section 3 of the City Civil Courts Act, comma, 1953 would have jurisdiction. Full stop. On the other jurisdiction under clause small b within bracket. So next para. On the other hand, comma, in any other suits, comma, covered by clause small c of Schedule IV, comma, the suit would lie to the Chief Judge of the Court of Small Causes constituted under the Presidency Small Causes Courts Act, comma, 1882 in the town of Kolkata. Full stop. Next para. Learned senior counsel argues that since the present suit has been filed under the 1997 Act, comma, section 12 capital A, comma, read with Schedule IV, comma, would mandate that the same was filed before the court of the small causes, comma, the valuation of the suit being admittedly much below the valuations stipulated therein. Full stop. Next para, learned senior counsel also places reliance on the valuation statement as given in the plaint itself, comma, which indicates that the suit was valued at rupees 4391 within bracket being 12 months last paid rent bracket closed and rupees 100 tentatively for recovery of damages and rupees 100 for permanent injunction, full stop. Next para, learned senior counsel next cites section 19 of the Presidency Small Causes Courts Act, comma 1882, comma clauses small d and small I of which respectively exclude the jurisdiction of the small cause court in suits for recovery of immovable property and suits to obtain an injunction. Which of next para, however, comma, it is submitted that the said bar is overridden by statutory mandate as contemplated in section 12 capital A of the 1997 Act. Which of next para, learned senior counsel also places reliance on the first schedule of the City Civil Courts Act, comma 1953, comma in terms of item 17 of which, comma, suits and proceedings triable by the small causes courts are excluded under section 5 within bracket 4 of the said act from the jurisdiction of the City Civil Court. Full stop. It is submitted that a composite reading of the aforesaid provisions would clearly go on to show that it would be the small causes court which had jurisdiction to entertain the suit. Full stop. Thus, comma, the City Civil Court lacked inherent stroke subject matter jurisdiction to decide the same. Full stop. Next para, in such context, comma, learned senior counsel cites such and such reported at 2019-17 SCC 82, where it was reiterated by the Honorable Supreme Court that it is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, comma, even at the stage of execution and even in collateral proceedings. Full stop. Next para, learned senior counsel next argues that as per the frame of the suit, comma, since the same was valued on the basis of 12 months rent, comma, the plaintiffs stroke respondents themselves perceived the jural relationship between the parties to be one of landlord-tenant, comma, thus attracting the provisions of section 12 capital A of the 1997 Act. Full stop. Next para, it is argued by learned senior counsel for the appellant that the appellant could not, comma, in any event, comma, be construed to be a trespasser, even if, comma, by operation of section 2 within bracket small g of the 1997 Act, comma, the tenancy of the appellant was to be taken to have determined. Full stop. Next para, in such circumstances, comma, it is argued, comma, the tenant would at the worst be a tenant at sufferance. Full stop. For such proposition, comma, learned senior counsel cites a coordinate bench judgment of this court in such and such reported at 2000 bracketed with the 2000 by 2 Cal LJ 70, comma, which was affirmed on merits by the Honorable Supreme Court in the judgment of such and such reported at 2004-13 SCC 448. Full stop. Both this court as well as the Honorable Apex Court, comma, it is pointed out, comma, affirmed the proposition that trespasser means a person who has been one from the very beginning and not one who had original title but lost the same because of efflux of time or by operation of law. Full stop. Next para, seen from such perspective, comma, it is contended that the suit was to be filed before the small causes court, comma, coming within the purview of schedule Roman IV within bracket small c, comma, read with section 12 capital A of the 1997 Act. Full stop. Next para, learned counsel appearing for the plaintiff stroke respondents controverts such contention on the ground that schedule IV of the 1997 Act applies only to a suit for eviction of tenants within the contemplation of the 1997 Act. Full stop. In the present case, comma, since, comma, by operation of section 2 within bracket small g, comma, the appellant was rendered a trespasser, comma, the suit was one for eviction of trespasser and, comma, as such, comma, did not come within the trappings of schedule 4 within bracket small c of the 1997 Act. Full stop. Next para, as, comma, under section 19 of the Presidency Small Causes Court Act, comma, no eviction suit lies before the said court, comma, it is argued that the suit was rightly instituted before and decided by the City Civil Court at Calcutta. Full stop. Next para, while deciding the aforesaid issue, comma, we take note of the status of a person who has been, whose tenancy, comma, otherwise devolved within the contemplation of double inverted tenant, double inverted clause, comma, as defined under section 2 within bracket small g of the 1997 Act, comma, has ceased with the expiry of the 5-year moratorium after the demise of the original tenant. Full stop. Next para, the status of such a tenant, comma, as held in the Nelly Marla, NELLIMARLA, jute mills case, comma, both by the Honorable Supreme Court and a coordinate bench of this court, comma, could at best be termed as a tenant at sufferance. Full stop. Next para, indeed, comma, a person is under normal circumstances, comma, labeled as a double inverted trespasser only if his entry point of possession was unlawful. Full stop. Next para, even proceeding on the said premise, comma, we do not find any qualitative difference between the status of a tenant at sufferance and a trespasser insofar as the applicability of section 12 capital A read with schedule IV of the 1997 Act is concerned. Full stop. Next para, the question which is relevant here is not whether a person was a trespasser or a tenant at sufferance, but as to whether he/she was a double inverted tenant within the contemplation of the 1997 Act. Full stop. Next para, although the suit in the present case has been valued on the premise of 12 months rent, comma, as is the case when a suit for eviction of a tenant is filed, comma, the mere valuation of a suit cannot be a valid determinant of the jural relationship between the parties, comma, which is otherwise governed by law. Full stop. Next para, even as per the frame of the suit, comma, the plaintiff stroke respondents have categorically pleaded that by operation of section 2 within bracket small g of the 1997 Act, comma, the status of the appellant was denuded of that of a tenant. Full stop. Next para, hence, comma, fact remains, comma, that as per the frame of the suit, comma, the appellant was no longer a tenant within the contemplation of the 1997 Act. Full stop. Next para, the language of section 12 capital A is very specific. Full stop. Irrespective of the non-obstante clause therein, comma, the said provision stipulates that a suit or proceeding তারপর double inverted মধ্যে by a landlord against a tenant, double inverted clause, in which recovery of possession of any premises to which the act applies is claimed shall lie to the courts as set out in the schedule IV thereof. Full stop. Next para, as per the frame of the present suit, comma, the same is not a suit for eviction by a landlord against a tenant, comma, be the defendant a trespasser or a tenant at sufferance. Full stop. Next para, hence, comma, the context of the judgments rendered in the Nelimarla cases is not squarely applicable to the present case. Full stop. Hence, comma, as per the frame of the suit, comma, since section 19 of the small causes presidency small causes court excludes the jurisdiction of the small causes of the said court from taking up suits for eviction, comma, the same was rightly filed before the city civil court at Calcutta, comma, being in view of the territorial jurisdiction coming within that of this court. Full stop. Next para. This court and the city civil court. Full stop. Next para. Next para the second heading টা হয়ে যাবে second যেটা heading টা হবে whether the appellant whether the provisions of section 2 within bracket small g of the 1997 act is applicable to the appellant in view of the appellant claiming tenancy rights through his grandfather, comma, who was the original tenant, who expired prior to the coming into force of the 1997 Act. Next para. Learned senior counsel for the appellant, comma, in the context of such argument, comma, cites Rajesh Mitra such and such reported at 2024 SCC Online SC 2607 and contends that in terms of the said decision, comma, once a tenancy right having accrued in favor of the original tenant prior to the coming into force of the 1997 Act, comma, the said Act cannot retrospectively take away such rights. Full stop. Next para. Learned counsel for the plaintiff stroke respondents opposes such prayer on the ground that the facts of the said case were distinguishable from the present. Full stop. In the said case, comma, it is argued by the respondents, comma, the appellants were the tenancy devolved on the appellants along with their mother, comma, Usha Mitra, comma, prior to the promulgation of the 1997 Act. Full stop. Hence, comma, it is argued that in such context, the Honorable Supreme Court observed that the operation of section 2 within bracket small g cannot apply retrospectively to take away accrued rights. Full stop. Next para. Upon a thorough perusal of Rajesh Mitra Supra, comma, we find substance in the contention of the respondent. Full stop. Next para. In paragraph number 4 of the said judgment, comma, it was recorded by the Honorable Supreme Court that the premises was originally let out to one Sri S.K. Mitra, full stop, subsequent to his death in 1970, comma, as per section 2 within bracket small h of the West Bengal Premises Tenancy Act, comma, 1956, within bracket the predecessor statute of the 1997 Act, bracket closed, comma, the tenancy devolved on his legal heirs who were ordinarily residing with him. Full stop. Thereafter, comma, upon quoting section 2 within bracket small h, comma, it was found that in other words, comma, in the event of the death of the tenant, the tenancy devolved on the legal heirs of the tenant, double inverted, who ordinarily resided with him, double inverted close. Full stop. In the case before the Honorable Supreme Court, comma, therefore, comma, the tenancy devolved on S.K. Mitro's widow and the appellants, comma, who were his children, aged 2 and 5 years, comma, italic say, at the time of his death, within bracket, emphasis supplied, bracket close. Full stop. Next para. In such context, comma, the Honorable Supreme Court went on to observe that if the literal language of section 2 within bracket small g was construed to be operative, comma, it would lead to an absurdity. Full stop. Next para. It was ultimately laid down in the said judgment that there is no ambiguity in case the original tenant passes away after the commencement of 1997 Act, comma, as in such a case, comma, it is clear that the specified heirs will get a limited protection of 5 years only. Full stop. We find such statement being recorded in paragraph number 12 of Rajesh Mitra Supra. Full stop. Next para. However, comma, in the event the tenancy devolved prior to the coming into force of the 1997 Act, comma, it was held by the Supreme Court that such substantive accrued rights could not be retrospectively taken away by the promulgation of the 1997 Act. Full stop. Next para. Applied, if the said principle is applied in the context of the present case, comma, we find that although the grandfather of the appellant became a tenant in the year 1910 and the father of the appellant, comma, the next in line of succession, comma, also inherited such tenancy prior to the enactment of the 1997 Act, comma, if the tenancy of the appellant's father Topon was challenged, comma, the principle laid down in Rajesh Mitra would hold good, and it could not be said that such right, comma, having accrued prior to the 1997 Act, comma, would also be taken away by section 2 within bracket small g of the said Act. Whose sub next para. However, comma, it is nobody's case that the present appellant also inherited along with his father Topon prior to the 1997 Act. Full stop. The clear case of both sides is that after the demise of Topon in the year 2009, comma, the right of the appellant to claim tenancy accrued. Full stop. Hence, comma, the accrual of rights, comma, so far as the present appellant is concerned, comma, is governed by the rider stipulated in paragraph number 12 of Rajesh Mitra Supra, which we have narrated above. Full stop. Insofar as the appellant is concerned, comma, his father Topon would be construed to be the original tenant. Full stop. On the demise of Topon after the enactment of the 1997 Act, comma, thus, comma, section 2 within bracket G would squarely be applicable. Full stop. Accordingly, comma, we hold this issue against the appellant and in favor of the respondents, comma, to the effect that the provisions of that the appellant is not the appellant's tenancy rights on the demise of his father were revoked stroke annulled after 5 years from the demise of his father in 2009, comma, by operation of section 2 within bracket G of the 1997 Act. Full stop. Third issue করে দিন। Third issue হচ্ছে whether, comma, by dint of issuance of rent receipts subsequent to the demise of Topon, comma, the appellant's tenancy right was independent tenancy right was admitted by the respondents. Next para. Learned senior counsel appearing for the appellants contents that by virtue of issuance of rent receipts in the name of the sole proprietorship, comma, which was then being run by the present appellant, comma, even after the demise of his father Topon, comma, the tenancy rights of the appellant was admitted by the respondents. Full stop. Next para, in reply, comma, learned counsel appearing for the respondent relies on an unreported division bench judgment, coordinate bench judgment of this court in FA 34 of 2012, bracketed Belarani Goswami versus Alok Roy Choudhury and others. Full stop. In the said judgment, comma, it was inter alia held that it is trite law that mere acceptance of rent after the expiry of the period of tenancy without anything more does not automatically create a fresh tenancy. Full stop. It is true that the assent ASSENT of the lessor may be inferred from the acceptance of rent, comma, it was observed, comma. But what is relevant is if such acceptance was made with a view to create fresh tenancy. Full stop. Next para, learned senior counsel for the appellant, comma, while controverting such proposition, comma, submits that in the present case, comma, there was something further than the mere acceptance of rent, comma, being that the rent receipts continued to be issued in the name of the sole proprietorship, comma, which carried through all along, comma, initially in the name of the predecessors of the appellant and then run by the appellant himself. Full stop. By dint of such common thread, comma, it is submitted that the tenancy rights of the appellant was acknowledged by issuance of several rent receipts. Full stop. Next para, learned counsel for the respondent further adds that all the rent receipts after the demise of the appellant's father were during the period of moratorium contemplated under section 2 within bracket small g, comma, the last of such of the same being issued till in the month of October 2010, comma, whereafter, comma, from November 2010, comma, the appellant started depositing rent with the rent controller. Full stop. It is thus contended that during the 5-year moratorium period after the demise of the appellant's father, comma, even under section 2 within bracket small g, comma, the appellant continued to be a tenant, comma, till he ceased to be so after the expiry of 5 years therefrom. Full stop. Next para, on a careful consideration of the arguments of the parties, comma, this court comes to the finding, it comes to the conclusion that as held in Belarani Goswami Supra, comma, mere acceptance of rent does not tantamount to creation of a new tenancy. Full stop. To establish novation of tenancy and stroke or creation of a new tenancy and stroke or the ingredients of holding over, comma, it had to be established by the appellant by positive assertion and evidence that there was an intention and consent on the part of the plaintiff's respondents to create a new tenancy in the name of the appellant. Full stop. Such creation would be premised on acceptance of the proposition that the earlier tenancy of the appellant had ceased to operate by dint of section 2 within bracket small g, and only thereafter a new tenancy was created. Full stop. We find utter lack of any evidence to that effect in the present case. Full stop. Even otherwise, comma, the respondents are justified in contending that all the rent receipts issued after the demise of the appellant's father, comma, the original tenant, vis-a-vis the appellant, comma, were issued within the moratorium period contemplated in section 2 within bracket small g of the 1997 Act. Full stop. Thus, comma, it cannot be said that subsequent issuance of rent receipts per se indicated that the appellant's independent tenancy rights were acknowledged by the plaintiff's respondents. Full stop, next para, তারপর conclusion heading করে দেবেন একটা. In view of the aforesaid conclusion findings, comma, we are of the view that no arguable case has been made out by the appellant in the present appeal. Full stop. The grant of eviction decree by the learned trial judge in the impugned judgment, comma, on the premise of operation of section 2 within bracket small g of the 1997 Act was justified and within the purview of law. Full stop. Accordingly, the appeal fails. Hence, FA 204 of 2024 is dismissed on contest, thereby affirming the impugned judgment and decree dated June 29, 2024, passed by the learned judge, 6th bench, City Civil Court at Calcutta, in title suit number 97 of 2016. Interim orders, if any, stand vacated. A formal decree be drawn up.
Wait.
Thank you.
ওটা বলতে গিয়ে ভুলে গেলাম। এখন ওটা বলতে বলতে গিয়ে মিক্স করে গেলাম। ওটা
এগুলো সব paper book নেই? Paper নেই?
Well, my lord, I am for the appeal. My lord, very short submission I will make before your lordships. But the scope of the appeal is limited.
Sir, can you please take the microphone a bit closer? You are for the other side.
I'm not a defendant in the suit, but I've applied for intervention and for vacating of the interim order which your lordship has passed.
He has been added.
Intervention has been allowed.
Oh,
He has been added.
I will hear you. Yes.
My lord, ad interim order of injunction was refused by the learned court below. Being aggrieved, we are before your lordships. The appeal has been admitted, and on 7th of February 2024, interim order has been granted by this honorable court, my lord, restraining the defendants in its main agents and servants from causing any annoyance and or disturbance to the plaintiff's petitioners. And this order is continuing. My lord, meanwhile, my lord, my learned friend's client has been added, intervener, and he has filed one application for vacating the ad interim order. That ad interim order of injunction so long was in force.
What was the prayer in the plaint, Mr. Ram?
Lordship, kindly come to my stay application or injunction.
Yes.
Yes.
Plaint has not been annexed.
Plaint has not been annexed, but the prayer portion has been stated.
Achha, where?
Lordship, kindly come to yes. My lord, kindly come to turning page 19. My lord, running page 19, my lord, the para 17, declaration that the plaintiffs are entitled to a degree for declaration that the plaintiffs being owners in respect of the suit premises 25 so and so, which is more fully and particularly described in the schedule hereunder written, has every manner of right to the peaceful use and enjoyment without any obstacle.
Ex parte ad interim refused.
Refused. So
you are the current Matwali, you say.
He's saying, my lord, may I submit one thing, my lord? Since the injunction application is pending and already they have filed one application to intervene in the title suit also. In all fairness of the matter, the appeal can be disposed of. Let the interim order continue. Let the injunction application
as well as his intervening application be
What was the
disposed of.
ground for refusal?
Nothing has been stated. No, Lordship, kindly come to the, admittedly the plaintiffs are in possession, page 2. Peruse the application. Admittedly, the plaintiffs are in possession, but the plaintiffs has failed to make out the prima facie case in order to get the identity order of injunction. This is the observation. Let it continue, my lord, for a limited time. His application is already fixed for hearing, intervening application. Let us fight there. Injunction after, if he's added as a party, my lord, the injunction application will be disposed of. He's at liberty to take all defense there. This is my short submission before your lordship.
And hear their long submission.
Yes, let them submit. My lord.
Not a long submission, Malad. First thing is, Malad, this property is admittedly a walk-off property, which
No,
is
not admitted.
is there in
This
their
is
deed.
not.
It is there in their deed. Lordship will have the deed of conveyance which the plaintiff has disclosed, page 25.
Now,
It is
Mr. Rai probably tried to indicate on the last occasion that it was a walk-off property when they
Yes,
purchased it.
it was.
By purchase, it has become secular. That was
But that your lordship has considered, Malad. I'm carrying that judgment that it can't be. If the sale is void ab initio, Malad, under the walk of fact,
But there is
section
no order,
51.
there is no degree that
But
the
I-
sale is void. You have not
But
challenged.
what we are telling you is that, I mean, here some arguable case has been made out. I mean, you are not yet a party to the suit.
I'm not.
That is one of the difficulties. Who was the defendant? The
That is
actual
no, Malad, it is a tricky situation which has arisen. Malad, the defendant,
vendor.
No.
fictitious person doesn't exist.
All
Malad,
have to take
the
this point
plaintiff
to
has
the
not
trial.
been able to. Malad,
We can direct the learned trial judge to take up you have filed an application for
Yes, he
impeachment
has
there.
already
Yes.
filed.
To take up that first, to decide that within a particular period, and immediately thereafter take up the injunction application. And subject to your being impleaded, you will be entitled to file a written objection there.
But insofar
Otherwise,
as
at the ex parte ad interim stage, you have to proceed on the plaint.
but the fact of the situation here is the plaintiff is not in possession of the property. I am in possession. Now, if the plaintiff gets an order that he has a right to use and enjoy the property, that will be used as a handle against me, who is not a party, who has not been added as a party to the suit, despite being aware that I am and it is a walk-off property, which is mentioned in the deed itself. On the face of it, the sale itself is void.
So, was the provision in the Walk of Act?
But section 51.
Walk of Act আছে আমাদের? You have got sufficient copies?
Yes, Manoj.
Then we'll take from you. ছেড়ে দাও ওনার কাছে।
দুটো আছে।
New book we want.
That will be old.
This is the new one.
না ওটা ওনাকে দেবেন না।
না ওগুলো
অন্যের বই একে দিয়ে দিচ্ছেন। যার বই তাকে ফেরত দিন।
দুটো দিয়ে দিন।
দাঁড়ান উনি ম্যাজিশিয়ানের মতো করছে। ওকে ফেরত দিন। Yes, which provision?
That's section 51 1A.
This new one?
New one. Any sale, gift, exchange, mortgage, or transfer of walk-off property shall be void ab initio. On the face of it, the deed itself, their document, which was there on record before the trial court. And they do not have any other document to show that they are in possession. They have not disclosed anything at all.
Let us see what they have pleaded in their injunction application at least, because we don't have the plaint.
Page 13 is the injunction application.
Lordship, kindly come to the.
Yeah, and it's the sale deed. You have purchased it.
Yes.
From that it will be evident whether it's a walk-off property.
Yes, but that is there. Page
23rd of December, long back.
Anything else you want to add? Then add. Then
no, this is my only point. And the fact which is not on record is that I am in possession. That
that we cannot go into. But
yes.
Very well. Let us hear Mr. Rai. Mr. Rai, there's a palpable an ex facie bar walk-off property transfer.
But when this new act came, kindly see the recital of my deed with permission. With permission, the property has been sold.
Which page? What is the page number?
Yes, page 25. 25.
For 25, the deed starts?
No, running page 31. Running page 31, the second recital. and whereas the vendor as Matwali of the said Waqf estate is seized and possessed of all that so and so, and whereas the said Nasiruddin Munshi as sole Matwali applied before the Commissioner of Waqf West Bengal for granting permission to sell the premises number so and so, there is a suit property.
Have you produced any document regarding those permissions or anything? No.
No, this is only stated in my deed. And
what independent proof of possession have you produced, Mr. Rai?
Yes, kindly come to my lord the other documents at running page, my lord, 52, 53, 54, 55, 55. These are there, my lord. They can dispute. This is to be considered, my lord. Not that we have annexed any.
The advertisements are very alarming at page 53. Page 53. Only electricity bills.
Yes. And we are staying there.
Electricity connection.
And we have lodged complaint, my lord, followed by 144(2), my lord, police inspection was there. What document they have that I am not in possession, they are in possession. Let it be decided by the learned court below. Injunction application is pending. The scope of the appeal is very limited to that extent. There is no specific findings, and rather the order in judgment impugn said that I am in possession, admittedly. He found the
admittedly. How could he say?
But
who admits?
He said
this is palpably bad.
Wrong.
But admittedly, person they are not appearing expert identity.
Let us forget that wrongly stated.
Defendant admits.
There is no admission.
So apparently, in the deed it stated. That's why the court arrived at that finding.
Yes.
And the defendant is the vendor. Yes.
And followed by the electric bill, etc., etc.
No, the defendant is the vendor. Your vendor, no.
No,
Some
no,
third
no,
party.
no. Third party. He is a stranger and he's coming and intervening and interfering in our possession. That is why he has been figured as a defendant. Let it be decided.
We smell some rat in your case. It has to establish. At this stage, it's very difficult to, because see, registered deed is there.
Yes.
First of all. Secondly, it's written there. Prima facie presumption is there.
But even that,
electricity bills, there has to be a meter.
And he
there.
sees the electricity bills, page 54, zero.
No,
Zero.
one is zero. There are 310, 500. Those are all.
And
we have checked up that. That is the first thing we checked up. 310, 500.
And there's a notice of disconnection also. Notice of disconnection in the same document. But I do not know how this proves possession.
37 unit.
But unless there is a meter there, prima facie is proof of possession. Definitely.
But I'm not on possession because the learned trial judge also did not have the occasion to consider whether they are in possession or not.
I just said admittedly possession, but that's a perverse order.
It is. But I'm not. I can't defend that.
That does not per se give him a right.
Yes.
Fourth mistake does not give him a right. But we independently also find there's at this stage, expert identity stage, at least, yes.
But if the deed itself, they do not have any right, and the defendant can't be served even by them or by me. All have come back.
Your implement application is pending.
No, but implement has yes. Before the trial court, it is pending.
The trial court, it is pending.
Tried to serve. Yes, so before the
we
trial
are now
court.
thinking of the trial court. Forget over here, it will be over today.
Well, the defendant does not exist. Well, as per the documents,
we'll record your submission, but we will grant an limited injunction.
But even on whether section 51(1)(a) was operative at the time of sale, because my learned senior friend has showed the page 31 of the deed, which says that permission was taken. Even that could not have been done without a public auction. That was the section which stood before the amendment. And I kindly sees if your lordship has the book,
yes,
that also.
এখানে কিছু হয়েছিল ওই ইজেক্টমেন্ট শুট হয়েছিল এইবারে
Where is the police report after the 144 order was there?
My lord, police report is
something is striking. 23rd, you purchased the property. 25th, you lost the complaint.
No. I have purchased long back, my lord. 1980. Lordship, kindly come to page 27. The 20 we have purchased, my lord, in 98. 98, my lord. 98. Page 25, my lord.
Where is the police report after the one?
Police report, my lord.
After the 144
That
order was
proceeding, only the order is there of the landed magistrate, my lord, at page 44. Police report, I have to take instruction, my lord, whether police report has been filed.
কোনো পার্টি নেই এক্সপার্টের এক্সপার্টের রেজিস্টার দিয়েছি যাতে লেখা হয়েছে কোনো পার্টি সেসব আছে হ্যাঁ ফুললি ডিসক্রিমিনেশন গুলো রয়েছে অ্যাভারমেন্ট গুলো রয়েছে ডিড টু ইটসেলফ পয়সা বিলো tentative বলে দিই
You are granting injunction for a limited period.
But well, kindly
Period of
consider
time.
two things, two issues. First is flood.
You can't even look into your documents or
No, not any document. Your Lordship's order of 10th April 2024.
that is ad interim. We forgot.
No, well, the Lordship's observed that the interim order Lordship is granting subject to the appearance of the respondent or any other party. That your Lordship had observed. Now, respondent has not appeared. Respondent
Cannot wait for them. That will go against you.
Yes, and what are the second issue?
If you interpret it in that manner, then we have to wait for that.
It is
Then the injunction will continue to be extended.
Yeah, because I have
want that.
But the second issue is what the how the act stood prior to the amendment, coming into effect of the amendment.
Yes.
51(1)(a) was incorporated in 2013. Prior to that, the section stood that the no Waqf property can be sold or leased or gifted or any manner whatsoever unless there is a permission from the board. Now, even if that permission is granted, a public auction was to be conducted, and only then a property could be sold or leased.
Have you got the previous provision?
No, it is there in the book. If I only have one copy of this. Section 51(1). But may I hand up the old book? Yes, but if that has one of the previous provision, that would suffice.
Yes, luckily that is there. Previous provision is quoted here.
My Lordship will see one of the previous
Notwithstanding anything.
Notwithstanding anything contained in the Waqf deed, any gift sales shall be void unless such gift, sale, exchange, or mortgage is effected with the prior sanction of the board. Provided nothing, no mosque, dargah, or khanda shall be gifted. Then subsection 2. Board may, after publishing in the official gazette the particulars relating to the transaction and inviting any objections and suggestions with respect thereto, considering all objections, etc., that may be received from the concerned mutawali or any other person interested in Waqf, accord sanction to such transaction, if these are the three conditions. Well, nothing is there in the deed.
No, but we don't know unless, I mean, there is a presumption of correctness. This is a registered deed of 1998, not of yesterday. So therefore, there is a presumption of correctness attached to it. So we cannot presume that the prior formalities were not done. If you go, somebody comes up and challenges, only then the court can look into that.
Well, that is what I am doing. Well, I have.
You don't have the locus standi as yet.
But in the appeal, Lordship has passed the
appeal is not. We cannot go beyond the scope of the trial court.
Absolutely not.
We are looking into the order, the veracity of the order of the trial court at this point.
And the documents on record, which were there before.
No, your arguments on law, we can definitely, on the basis of the documents which are there, you are arguing.
Yes,
we get that. Yes. You are arguing only on the basis of that. The law you are arguing, which you are perfectly entitled to do. But even if you consider the law, unless the specific averment is made that those were not complied with, there is a presumption that official acts were done correctly.
But it only says, the deed only says there is a permission. That is all. The deed does not say that the permission was granted after complying with all the formalities.
Need not. Permission granted presupposes that the formalities were complied with. That is an official act. It's a The permission by the commissioner of Waqf, this,
Yes.
not the board though.
Not the board, it's a commissioner of Waqf, and the Mutawali who was there at that point of time, they have been, it is, there are some fraud that was perpetrated, and that way he was.
That is
Well,
to
that's
bring
not
on
on record. I will not argue on that.
Bring on record.
But my only apprehension is this is a Waqf property which is mentioned in the deed itself. Now, taking advantage of this order obtained from the court, well, they will use it as a handle against me. Whereas I am in possession of the property and I have a right over the property. That is the whole apprehension.
Don't know as yet. You have to be blind to that.
Well, since the Mutawali is represented, the current Mutawali is represented before your lordship, lordship may give some protection to the property itself. They cannot take advantage of some misdeeds.
Only
Which are
regard, injunction regarding possession. Tomorrow you can go and file a suit also and ask it.
Yes.
You don't need to advise you.
Yes, that is
Whatever
what
it-
provisions are there in the act itself.
The present appeal has been preferred against an order whereby the petitioner's prayer for ex parte ad interim injunction was refused by the learned trial judge. First of learned counsel for the appellant points out that the learned trial judge, despite holding that admittedly the plaintiff stroke petitioners are in possession of the suit premises since 1998, went on to observe that the plaintiff stroke petitioners have failed to make out prima facie case in order to get ad interim injunction, and that balance of convenience and inconvenience was not in favor of the plaintiff stroke petitioner, and as such refused injunction. So next para, however, it is pointed out that the said observation is cryptic and contradictory, and no conceivable reason has been ascribed in the order to hold that the plaintiff does not have any has not been able to make out, plaintiffs have not been able to make out any prima facie case. For next para, moreover, learned counsel places reliance on the registered deed of conveyance in favor of the appellants dated December 23, 1998, which was overlooked by the learned trial judge. From the same it is argued that it will be evident that due application was made before the Commissioner of Waqf West Bengal by the vendor, the then Matwali, seeking permission to sell, which permission was subsequently granted, and only thereafter the deed was executed. Thus, it is argued that the learned trial judge acted without jurisdiction and erred in law in refusing ad interim injunction. Next para, learned counsel, although none appears for the respondent, learned counsel for the added respondent submits that the said added respondent is the present Motwali of the property, subject property, which is admittedly a Waqf property. As per the added respondent, the defendant stroke original respondent is a fictitious person. It is submitted that taking undue advantage of the order of injunction, if any were to be passed, the appellant would assert title over a Waqf property despite a transfer of Waqf property being void ab initio by dint of section 51 within bracket 1 capital A, as amended in 2013. Next para, even under the previous provision before the said amendment, it is argued that under the previous subsection 1 of section 51 of the Waqf Act 1995, notwithstanding anything contained in the Waqf deed, any sale, etc., would be void unless it was effected with prior sanction of the Board of Waqf. Next para, moreover, under subsection 2 as it then stood, the board, such permission had to be preceded by publication in the official gazette, the particulars relating to the transaction referred to in subsection 1, inviting objections, suggestions, etc. with respect thereto, and only upon considering all objections and suggestions, if any, that may be received from the concerned Mutwali or any other person interested in the Waqf, the sanction could have been accorded under the circumstances as enumerated in clauses small I within bracket to small III bracket thereof. For sub next para, in the absence of proof of any such foundational facts, comma, it is contended that even on the basis of the materials produced by the plaintiff stroke appellants before the trial court, comma, the learned trial judge was justified in refusing injunction. So next para, from the it is upon hearing learned counsel for the parties, comma, we find that a registered deed of conveyance, comma, not of recent origin but of December 23, 1998, purportedly executed in favor of the appellants, has been produced in the trial court. For sub next para, it is well settled that official acts carry a presumption of correctness, comma, unless rebutted. Full stop. At the ex parte ad interim stage, comma, the averments made in the plaint and the injunction application and the documents relied thereon are to be taken as sacrosanct for the limited purpose of deciding such ex parte ad interim prayer. Full stop. Next para, proceeding on such anvil, comma, a prima facie case of title has been made out. Full stop. In the deed itself, comma, it is stated that permission was obtained from the commissioner of Waqf by the vendor, who is claimed to be the then Matwali of the Waqf property. Full stop. Next para, unless such presumption is rebutted or at least assailed by way of specific pleadings of and particulars, comma, it cannot be said that the plaintiff stroke appellants did not make out a prima facie case of their having obtained a valid title and their possession as to the property. For sub next para, even the learned trial judge recorded in the order, comma, although somewhat absurdly, comma, to be double inverted clause, comma, which could not be the case, comma, that the plaintiff's appellants are in possession of the property. Full stop. Next para, even independent of such observation, comma, we find that certain electricity bills in respect of the subject property were furnished in the trial court by the plaintiff's appellants, which create a prima facie presumption of possession, comma, coupled with the registered transfer deed in favor of the plaintiff stroke appellants. Full stop. Next para, the disputes, the objections raised by the respondents are premature at this juncture, comma, since the respondents, comma, who have only filed an application for addition of party in the trial court and have not yet been impleaded, comma, do not have the locus standi as yet to controvert the prayer for injunction. Full stop. Next para, be that as it may, comma, we are of the opinion that on the materials before us and which were before the trial court, comma, a sufficient prima facie case for grant of injunction in respect of possession has been made out. Full stop. Next para, however, comma, for the ends of justice, comma, the respondent's application for impleadment as party to the suit is also required to be taken up expeditiously, comma, prior to deciding the injunction application finally, in order to put a terminus to the issue of the locus standi of the respondent to oppose the injunction application. For sub next para, accordingly, FMAT 10 of 2024 is allowed on contest, comma, thereby setting aside the impugned order. Oh, sorry, FMA 208. Thank you. FMA 208 of 2024 is allowed on contest against the added respondent and ex parte against the original respondent, comma, thereby setting aside the impugned order bearing order number 2 dated January 3, 2024, passed by the learned judge, 13th bench, City Civil Court at Calcutta, in title suit number 08 of 2024, and granting an injunction restraining the you can only restrain the original respondent
at this stage.
The defendant stroke original respondent herein from disturbing the possession of the appellants in respect of the suit property till disposal of the temporary injunction application in the trial court. Full stop. The learned trial judge shall, positively within 3 weeks from the date of communication of this order to the learned trial court, dispose of the application filed by the added respondent herein for their implement in the suit, upon giving an opportunity to the full stop now, and decide the same. Full stop. Written objection to such application for addition of party, if any, shall be filed by the present plaintiff strokes appellants within a week from date in the trial court. For sub next para, immediately upon adjudication of such application, the learned trial judge shall make all endeavor to dispose of the injunction application at the earliest, depending upon subject to the outcome of the addition of party application. We say this because if it is allowed, then it will be granted over.
Lord, the copy they have filed, but the copy has not been served. Let them serve the copy, my lord.
Order 1 to you have annexed to your addition of party application.
Order 1
They haven't annexed here. Oh,
that can be.
We shall serve. We shall serve.
A copy of the addition of party application filed by the added respondent in the trial court shall be served by tomorrow on the learned advocate for the appellants in this court, which will be deemed to be good service on the appellants themselves.
But this will not prevent the Mutawali to take appropriate steps in law.
We have directed your application to you.
No, my lord, in otherwise available in law. My lord, under the
We have granted injunction only against them. Why should we do it?
And my lord,
We have not restrained you in any manner.
There was a direction to file rejoinder affidavit against their application. We have already served. Let it be kept. Yes.
প্রথমে একটাতে ঢুকিয়ে দিয়ে শুভ যে rejoinder affidavit file to be kept.
Grateful, man.
Thank you.
Grateful.
Next.
That this is the fourth of the appeals, my lord. 3 appeals, my lord, for rejection of plaintiff your lordships have heard. That this is
different.
This is slightly different. But my lord, the
depending on the outcome of the others.
Not really. But my lord, I'll only tell you lordship this, that my lord, so far as this suit in which my lord the application was made and my lord order passed, which is now assailed before your lordships, my lord, the counterclaim filed in that suit has been dismissed. That is an appeal before your lordships.
Mr. Banerjee and Mr. Shah, both of you, in all probability will deliver judgment in that matter 10:30 Monday. So we'll keep it just after that. We'll keep it on Wednesday. We'll keep this. There may be some ramification on this, whichever way it goes. Very well.
taken on record না এটা না এর সঙ্গে এটা ছিল ওটা অনলাইন চলছিল ওইগুলো করতে হয়েছে লাস্ট মোমেন্টে দেখা গেল আলাদা ও এই জন্য এটা কি সব নিয়ে ওটার জাজমেন্ট হয়ে যাবে সব এক্সেপ্টিং এতে রিজার্ভ ফর এটাকে ডিটেক্ট করে আলাদা করে
Since there are some subsequent facts which are to be brought to my lord's notice, my lord. But do we use an affidavit to that effect?
Mr. Banerjee, you have challenged what order in this?
But this is the injunction order, second injunction order granted.
Contested injunction.
Contested
This is
injunction.
only, my lord, to the extent that, my lord, the bank account where, my lord, the monies were to come in should not be closed.
So if they want to bring in some documents.
I don't mind. Order 41, Rule 27.
But it will be done.
Subject
It will be done within Monday, my lord, so that they get an opportunity, even if it is placed on Wednesday before your lordship, my lord.
Opportunity to peruse your application.
Yes, but nothing
Not
more would.
opportunity to
But
file
nothing.
objection, they won't be able to file.
Nothing more would be required, my lord. These are all facts which have come. Yes.
Learned counsel for the appellant seeks an opportunity to bring on record certain further documents by way of an application. full stop. In order to enable such application to be filed during the course of this week, comma, let the matter stand adjourned. In order to যেটা বললাম enable course of this week and service of an advance copy of the same on the learned advocate on record for the respondents, comma, the matter is adjourned till August 19, 2026 when it will be listed under the same heading. It is made clear that the that objection, if any, comma, to the proposed application are kept open for being argued at the time when the matter is taken up for hearing.
Well, only one indulgence, but kindly keeps it the week thereafter, my lord. These are Punalur people from Kerala, my lord.
Definitely. So we'll keep it Wednesday week then?
Lordship.
August 26th then?
But
26th August.
But in a position so that it can be taken up, my lord.
All the things under the sun you cannot. Position
If it,
will be same.
My lord, if it goes down, my lord, very difficult to get
Date will be same. Position will be same.
Matter will be taken up at
But otherwise, if your lordship may kindly permit,
matter will be taken up at 3:20 and
but
allowed.
we can proceed with it today also, my lord. But certainly, my lord, the Mondays,
The entire universe will undergo so many changes in between.
my lord, the entire money that has come into the account has already gone to their
Universe
pockets.
is more universal than money.
More will come, my lord, because they're not entitled to anything.
That is their stand, my lord.
My lord, 26th, my lord, could possibly be a holiday. I don't know, my lord, that.
Then we'll fix it on that date only. We have fed up of these appeals.
26 তারিখ ছুটি হবে, yes.
26 forward.
That Fateh was the Hamasan. Oh. Well, it's not yet marked as a holiday, but my lord.
No, the week thereafter, my lord, no difficulty.
Week thereafter?
But unless it is that, my lord.
No, we'll keep it on 25th then.
Yes.
Very well. But 25th.
25th.
Lordship. I'm grateful.
Out of the reserve রেখে দেখা গেল পরে করে পড়ে
Lord, I beg to appear for the appellant.
Yes, Mr. Raut. You are there. Yes.
Yes. The defendants appellant before your lordship. This is a suit for declaration, partition, and injunction. Lord, they filed the suit against us, the appellant before your lordship, and got the injunction, temporary injunction till the disposal of the suit. Lord, restraining us from constructing the building and also from transferring any portions of the building. Lord, challenging that order, judgment and order, Lord, we came before this honorable court and filed this appeal. Lord, first, Lord, I want to show your lordships the impugned judgment. So this is very interesting judgment. If your lordships kindly have a look of the memo, my memorandum of appeal.
Yes.
Lord, may be allowed to read?
Yes, yes, please.
Now, today is fixed. No, that is the order number 11, dated 11 June 2024. Today is fixed for passing order in regard to injunction application under order so and so. The record is taken up for passing order. Peruse the petition and its objection. The main contention of the petition is that one Manmothanath Mondal and others were the owner of the scheduled property, that by way of amicable arrangement against the co-sharers, Manmothanath Mondal became the owner of a scheduled property, and the same was recorded in his name in RSROR. While he is possession in a scheduled property, he died leaving behind 4 sons, so and so, so and so, and so and so, and so and so.
He's also there.
Oh, I have not seen Lord. That's why I have not seen Lord.
Let him take his breath.
Yes. Lord. So and so, and 2 daughters, Malati Mondal and Aruti Mondal, and wife Ostobala Mondal, as his legal heirs and successors. Each of the legal heirs of Manmothanath Mondal inherited 1/7 equal share. The name of Aruti Mondal and Malati Mondal for the A scheduled property has been recorded. Aruti Mondal used the same with other co-sharers, but subsequently Aruti Mondal transferred her share to her constituted attorney Dipankar Sarkar to the plaintiff Mohadev Das by virtue of a registered deed of sale being number so and so, and also delivered her possession to the plaintiff. Now, this is wrong, absolutely wrong, my lord. Their statements because we are in possession, we have constructed G plus 4-story building. That Malati Mondal also transfer her share of A schedule property to Kinkor Roy by a registered sale deed being number so and so. After purchase 1/7 share, Kinkor Roy thereafter transfer the said land to the plaintiff by way of sale deed being number so and deliver cash possession to him. So the plaintiff by way of purchase became the owner of 3.42 decimal of land in respect of the A schedule property. That sometimes in the last part of December 2023, some unknown person started to make fencing around the A schedule property. On being informed, the plaintiff rushed to the spot and obstructed the fencing and asked them about their identity. They told the plaintiff,
should I disturb? No, what is the question of disturbing? Yes.
Because what I'm thinking, I have talked with Mr. Bhattacharya.
And they have 2/7 share.
Hmm.
I am ready to give him the share which they are entitled. The suit may be decreed also.
Then you enter into a compromise formal arrangement.
Let us have a talk, my lord. I have a talk just now with him.
Fair
He's
enough.
agreed.
Not agreed, my lord, agreed to talk, but
Yes, right.
not about
Agreed to talk.
agreed
No,
to talk.
he's-
Sir, Raut agreed to your agreeing to talk. That is the first thing which has to be.
He cannot claim beyond his plain case. So
but we accept, Lord, their plain case. Even if we accept their plain case, then Lord, they cannot
That is
claim.
what we are saying. So
he's agreed. Now,
does he
it appears.
agree that
He agrees to agree
You
to
agree
talk
to
to me.
agree?
Yes. Now he is agrees. His statement is this.
very well?
Give us a week's time, my lord, so that in the
1 week,
meantime
yes.
we can.
2 weeks.
One,
No,
one week.
1 week.
One
Week's time. Sorry. At the outset, at the very commencement of hearing, learned senior counsel appearing for the appellants submits that the matter that there is a chance of the matter being resolved amicably, to which learned counsel for the respondent agrees in principle. Push up next para accordingly, to explore the scope of amicable settlement, let the matter stand adjourned till August 2026 when it will be listed under the same heading. Next Thursday in between.
Yes.
এই ক্যালেন্ডারটা পুরো ওদিকে ঘুরিয়ে দিতে পুরো ঘুরে যাবে এরপর না আপনি দীপঙ্কর তুমি হাত যাবেন সেটা
My maiden appearance yields some result.
Pardon?
Maiden appearance before this bench.
Suppose this bench আছে
I'm grateful to Lord.
yes
My lord, I refuse petition. Appellant, my lord.
এগুলো রেখে দিতে পারেন সিটি সিভিল কোর্টে যাওয়ার লাগে yes Mr. Ghosh, what is the matter?
My lord, the suit for dissolution of the marriage on the ground of cruelty.
Your suit dismissed or
dismissed? My lord, husband did not give any evidence. Only cross-examination of the petitioner's wife before the trial court. Only written statement was filed. No evidence was given by the husband. Matter was taken up for expert hearing. That is the last order sheet. That is the
no, here also it is proceeding expertly.
Expert. In spite of serving notice, he is not turning up. Mother, Lordships, kindly see the order passed by your Lordships. But that is order 20th January 2025, Lordships order. The respondent has deliberately avoiding service while disposing of can 125.
Notice of appeal has been served. We don't.
Yes, served.
Those have been served.
Yes, my Lordships observed by passing order dated
Yes,
28th
yes,
January.
Yes, right.
That the respondent husband is deliberately avoiding service.
Right.
Proper service has been effected on the respondent.
No, but that was the service regarding the applications, Mr. Ghosh, not the appeal. Not the appeal.
Lord, appeal, I put the requisites, my lord, in view of the Lordship's order. And also prepared the.
No, you didn't check up whether it's ready for hearing, whether that is there before mentioning the matter.
ABJP service, my lord.
also file.
একটু দেখুন তো রেডি ফর হিয়ারিং স্ট্যাম্প আছে কিনা তো না হলে কি দেওয়া যায় তাহলে
This is the postal tag report, the address is received from the postal tag report.
সার্ভিস হচ্ছে না last report of the office is Mr. Ghosh address he left. So that's not good service per se. So then we have to, we'll keep it in the list. You just effect substitute service, Mr. Ache. There is no, the last report of the office, as my learned brother rightly points out, that there is a report, but it says address he left, that is the last. And
May I serve notice again upon the by speech post? That matter will be taken on next day.
Speed post will yield the same result. If the address is left, how can you, it won't help you. You make a newspaper publication, will give you 2 weeks. Only one person, sir.
As you lordship jare. Trial court also, last, that is the last order.
They did not.
Kindly see the last order of the trial court.
Yes.
He was directed to show cause, none appeared, nothing. This is the last order, 5th July 2023. He didn't turn up in his show cause.
Right. They're deliberately avoiding, that's obvious, but the address he left is the last endorsement.
No, let I shall make
We find from the office reports that the notice of the appeal could not be served apparently because the addressee has left his last known address. So accordingly, we direct the appellant to effect substituted service by publication of notice in 2 daily newspapers having moderately good circulation in the area of the last known address of the respondent, comma, one of which should be in English and the other in Bengali vernacular.
My lord is intelligence, very poor woman, my lord, having no, my lord, only one newspaper, my lord, having no source of income. Even he is not paying maintenance amount.
One newspaper, Bangladesh. যা বললাম তাই শুধু 2 না করে 1 in Bengali vernacular in the area of the last known address of the respondent, which of the appellant shall file an affidavit of service in that regard on the returnable date. Let the matter be placed under the same heading on August 27, 2026. We're giving you 2 weeks. 2 weeks, Mr. Ghosh. One Bengali newspaper.
I'm deeply offended.
The one which is least read. Cheapest has to be
cheapest.
Well, Mr. Ghosh, my learned brother, has a comment to make.
Yes, also.
It's difficult to believe that your client is.
Well, he's present in court.
No, difficult to believe that. He's saying that difficult to believe that your client is not solvent enough to.
Yes. No.
Particularly.
Oh, no.
A lot of things are there. We'll blackmail you with this. Whenever we find that you are arguing and not stopping and anything like that, we'll blackmail you with.
Okay.
Thank you, sir. Next.
Lordship also purchase this.
Yes. Everybody, it's common knowledge.
I am appearing for the respondent.
Respondents, the other. You exchange places, Mr. Ghosh. You appear for the appellant and respondent. So we have either the appellant or the respondent is not present before us.
Yes.
It's the other way around now.
Now today 3:30. Problem is.
Oh, there's a 3:30 today. Achha, achha, achha. Okay. We will not dismiss matters. Although the respondents are represented through counsel, none appears for the appellants at the time of call. Let the matter stand adjourned for the day.
It is the bar resolution 3:30.
Oh, achha, achha.
My lord, may I file opposition to their application for amendment? No, on the day.
No, file it. The affidavit in opposition to the amendment application, comma, filed today by learned counsel for the respondents, comma, be kept on record. You can inform the other side's advocate, Mr. Mitra, if you can. Verbally, we are not directing you, just inform.
Item number 17. Well, this is my appeal.
Yes.
Very short question. Brothers inherit property from the father who died intestate. One brother takes 7 lakh rupees from another brother, issues a promissory note, a money receipt really, issues a money receipt, recognizing that he has received this 7 lakh rupees and says that my 1/7 undivided unpartitioned share will be transferred to you. A sale deed will be executed to you in due course of time and my descendants will not take any objection. I file a suit for specific performance.
They say that in writing?
Yes. In the money receipt, he also records the promise. So thereafter, I file a suit for specific performance. My suit for specific performance is served upon them. Does not appear. We conduct substituted service. They never appear. However, I still suffer an ex parte order. My lord, kindly
but
first.
Is that resolution? You have that resolution. We forgot that.
But they have never appeared.
We'll give them a last chance. We'll record that they're not appearing. You are appearing. They're not appearing. Nobody appeared for them at any point.
Nobody appeared for them even at the trial court stage, despite substituted service. I can show that order.
You'll have to provide security guards if the bar comes after us. We have no problem. Let us take up the matter.
I don't think anybody will come up.
থাকলে সবাই করে আজকে প্রথম দিক চার বুথ সাইড থাকবে যদি আমরা করে থাকে বুথ সাইড থাকে
We'll give them another chance. Let us give them. None appears for the respondents at the time of after being apprised.
Yes.
None appears for the respondents at the time of call, although the appellant is represented through counsel. For sub next para. As a last chance to the respondents to contest the matter, the same is adjourned till August 20, 2026. Full it is made clear that in the event the respondents remain unrepresented on the next occasion when the appeal is called on for hearing, ex parte order may be passed against the respondents.
Item number 18.
Not today. You're appearing in it?
Yes, yes.
Sorry. Yes.
Well, I'm appearing on behalf of the appellant that there are some talks of settlement going on between the appellant and the respondent, and they have sent a draft of settlement agreement also. So I'm asking only for a period of 15 days so that
we are putting it out of the list. If you have it settled, then come and mention. We'll pass an order.
Mind.
Learned counsel for the parties apprise the court that talks of settlement are going on between the parties. Full stop. To enable the matter to be resolved by amicable settlement, comma, let the same go out of the list with liberty to the parties to mention for enlistment as and when such settlement is arrived at.
Grateful.
Thank
Yes, I am for the appellant. Respondent not avoiding my deliberately.
No, we know that, but the previous occasion.
In my lord, kindly ex parte. Previous order, my lord, 17.
Same order will
17, my lord. Previous order 17 as.
No, same order as the last matter will pass in your matter also. That you are appearing, they are not appearing. We are giving them a last
Not-
chance.
Not on the last 17 matter, my lord, ex parte hearing has been dictated, my Your Honor, kindly. If they did not
Yes, yes, that
appeared,
we are meaning that one only. The same order.
same order, 17.
You have marked the matter number also.
Yes, my lord, I am hearing.
Right. We are passing similar. Not good enough.
But I am on behalf of the respondent, my lord. My lord, in this matter, my lord, can remember, my lord, in this matter, my lord, the number, lordship, on the last occasion said because of some difficulties, lordship, under which heading the matter will become. After that, my lord, the matter has been in different numbers. Then, my lord, the matter will come, lordship, on 15th July 2025, and my lord was pleased to condone the delay, my lord. I was not appeared because I don't know the number. After that, my lord placed this matter under the heading hearing. If your lordship kindly allow me to place a short affidavit, my lord, in this matter.
What is this? This is challenging is what?
My lord, challenging the adjudicating officers of my lord. Remember that
There's no scope of affidavit here. It's an appeal.
since when it is an appeal, my lord, only right to
On law.
my lord, since on the appeal, my lord, on the grounds of appeal, my learned friends raised upon lordship. If your lordship kindly allow me on the short affidavit, my lord.
Grounds of appeal are legal points.
Then it is up to the lordship. I will.
You're appealing for the appellant. Mr. Banerjee,
সাহেব কি বলছেন?
you're appealing for the appellant in this matter.
No, item 18, I was for the respondent.
If you are appealing, then must have been dismissed for default.
I was for the respondent, so
then must have been allowed.
If you then lordship kindly give a 2 weeks time, my lord.
Why 2 weeks? No, next week come prepared.
You
You are always prepared in every matter. Come prepared.
I am ready. I will.
Yes. We are putting it on him this time. The appellant. But next time it will be you. None appears for the appellant at the time of call. Full stop according this. Appellant at the time of call, although the respondent is represented through counsel. Full stop, let the matter stand adjourned till August 20, 2026. Next Thursday.
Yes, your lordship. I will come.
Come prepared on that.
I will come.
My lord, due to difficulty, my lord, kindly adjourn for one fortnight because
Fortnight, no. Why?
one of the my lordships he has already appeared. That is why for adjourned I'm taking. If determination changes, I can proceed.
Who appeared? Justice Day?
Yes.
No, it goes out of this. Determination will not change so soon.
That is, my lord, the Chief Justice will come and determination will change.
22 years, 20.
Yeah.
In view of one of us, within bracket, Justice Day Namta, Puro Namta, having appeared for a party, for one of the parties, while at the bar, comma, for the sake of judicial propriety, let the matter stand released from our list on personal ground, with liberty to the parties to approach the Honorable the Chief Justice for the purpose of assignment before a different bench. Thank you. Not true. Just any matter where both sides are present, otherwise you are not taking up. You have a resolution, so they're taken up. There are not even number of people, so both parties won't be appearing in any matter. You are appearing for both parties in this matter.
No, my lord, to item number 18.
18, whatever happened. We don't know.
My lord,
Let there be a
they have submitted that there is a talk of settlement, but I have taken instruction.
Both sides were there.
No. Respondent, I am for the respondent. I just called up my client. My lord, there is no talk of settlement, my lord.
Point out on the next occasion. It will be on
item
record.
18.
Priti Sharma.
No, PS, Priti Sharma.
Priti Sharma.
Yes.
18 record করেছে ওটা
My lord, I beg to appear for the respondent.
Priti Sharma versus Akhilesh Sharma.
Yes, I am for the husband. Husband has succeeded in the suit for divorce. Against that, they have preferred an appeal.
Both sides appeared and said.
She was present.
I was present. I
There's a-
did not give the consent. I was just present.
There was a settlement talk going on between the parties, my lord.
My lord,
I'm for the appellant, my
but I
lord.
just called my client. My lord, yes.
Appellant respondent are here.
What
I
here?
was
My lord, I
there, but I did not give
Madam,
any
आपने
consent.
ठीक.
I
Who
was
has
here.
given you the wakalatnama?
You are for the respondent.
Yes, I am for the
I'm
respondent,
junior
Mr.
of Ganesh Narayan Jajodia, sir.
My lord, I have.
he contacted me, Mr. Jajodia. He's for the, I think he's for the respondent.
My lord,
That Akhilesh Sharma.
I just cleared the doubt. Mr. Ganesh Jirodia is the advocate on record, my lord. I just had a talk with him personally, my lord. He has said there is no talk of settlement.
18 এর তাহলে অর্ডারটা রেকর্ড করে ওটা জাস্ট কিছু রেকর্ড করতে হবে না we are making it not today just ascertain resolve this issue
I just called him, my lord. That's why I was.
we are just making it not today we are not recording any order then ওই অর্ডারটা রেকর্ড করতে হবে না we are not recording any order since all sides are here we are not recording any order you please ascertain it will be in the list it will be taken up on next Thursday then.
I'm grateful, my lord.
In any event it wouldn't be heard today because both sides are not ready
But I'm ready. But I'm ready.
both sides are not ready
বলবেন আপনারা